I'm the petitioner in person of item number 63.
Huh. What do you want?
Lordship, can this case be preponed? It is actually in the, I think 63 in the last of the cause list.
We'll take it up after the top of the list items. Motion, top of the list, then I'll call up your case.
Maybe Lordship. First one urgent matter, Lordship. It was filed day before yesterday, Lordship.
What is the urgency?
Urgency is Lordship. The official response, Lordship. Person speaking order, Lordship. Whereby they rejected my transfer, and as well as the direction given that he have to join with.
What is
Lordship, another direction, Lordship. He has to join within 7 days. Otherwise, legal action will be taken.
Really?
So now I cannot join, Lordship. There's at least that.
Why you can't join?
Lordship, actually, I have to reassert outside, and due to my medical
You've
issue.
gone outside taking permission from the respondents, informing the
No,
respondent.
informed, but that's why he's given petition that he cannot join there.
Monday.
Monday, Lordship.
Good morning, sir.
Yes.
Sir, my item number is 25, sir. You said-
We'll reach there.
Okay, sir. Thank you so much.
May I please, Lordship? Lordship, I beg to mention for listing, Lordship.
What is the admission?
Lordship.
First week, second week?
May I please, Your Lordship?
Listing, give it to her. She will.
But next Friday will it?
Whenever. So, first week.
May it please Your Lordship, with the consent of the other side, I beg to mention item number 41 and 42.
41. Why?
Sir, kindly grant us 1 week time to file our affidavit.
Affidavit? Reply.
No, Lordship.
You are for SP Das.
SP Das for response number 5 and 6.
Prayer is made on behalf of the Learned Standing Council Employment and Craftsman Training for an adjournment in the matter for 2 weeks to facilitate filing of affidavit in the matter. Also, prayer accepted. Have you informed the petitioner?
Yes, Lordship. I'm appearing for the petition.
Prayer is not objected to by the Learned Council for the respondents. Accordingly, matter stands adjourned for 2 weeks. The respondents shall invariably file their affidavit in the matter on or before the next date of listing. Registry to list this matter again on after 2 weeks on a date to fix it. Utat, 41, 42 together.
Lordship, date may be fixed, Lordship.
Come, 26 matter. Come. Yes.
Sir, Lordship, there is an interim order.
Interim order passed earlier to continue till the next date of listing.
Lordship.
Yes. Yes.
Now, please, Your Lordship, with the consent of the other party, I beg to mention item number 32, Your Lordship. Your Lordship, regarding this matter, we were to obtain updated instructions, Your Lordship. We've communicated, however, the instructions are still awaited, Your Lordship.
This is the second time you have been given time. Why the respondents are not responding? He had prayed for regularization plus minimum pay.
Yes.
Regularization pay prayer outright rejected. But the minimum pay is as per your own circular.
Yes, Your Lordship.
A prayer is made on behalf by the Learned Standing Council Finance Department for a further adjournment in the matter to complete instructions in the matter. Prayer is not objected to by Ms. M. Bora, Learned Council for the petitioner. In view of the above, a last chance is granted to the respondents in the Finance Department, Learned Standing Council Finance Department to complete her instructions in the matter. Registry to list this matter again on 21/8/2026. 21. Any problem? Friday.
20.
Huh?
20.
20. No. You are having some problem in 21.
My senior instructed me to
24?
Wednesday.
24?
Wednesday, any Wednesday.
Okay, 19.
That put a order me up for small correction. Maybe your lordship, item number 70.
70.
70. It's a 22 matter. I've been informed yesterday night. The respondent number 6, 7, 8, 9, and 11. These are private respondents. They wish to enter appearance now. So they will be executing an wakalatnama today itself. So I pray for at least 2 weeks time to file my reply to it. And in fact,
Who is for the petitions?
I'm for the petition.
Any objection? Mr. Ardas, learned,
RJ Das.
RJ Das, learned, submits that he is under instructions to appear in the present petition on behalf of the respondents number
6, 7, 8, 9, and 11.
6, 7, 8,
9, and 11.
He submits that the power would be filed within the next week and prays that he be granted 2 weeks' time to file a affidavit on behalf of the said respondents. Prayer is not objected to by the learned counsel for the petitioner. Also, in view of the above, registry to list this matter again after 2 weeks. Registry to list this matter again on 12/8/2026.
Deeply obliged.
May it please your lordship, with the consent of other side, I beg to mention item number 30. The conducting counsel, Mr. B. Patel, is out of station on medical grounds.
Mr. Kumar was appearing. He is also out of station.
He is also not available.
A prayer is made on behalf of Mr. P.P. Pathak, learned, P. Pathak, learned, counsel for the petitioner for an adjournment in the matter on the ground that he is presently out of station. Prayer is not objected to by the learned counsel for the respondents. Also, accordingly, registry to list this matter again after 3 weeks on a date to be fixed by.
Lordship, in item number 29, IT filed affidavit in opposition on 16th. I pray for 2 weeks of time for filing reply
You are appearing for?
on behalf of NJ Gogoi.
First, satisfy this court on maintainability. Ask Mr. Gogoi to satisfy this court on the issue of maintainability. Let him come.
My pleasure, Lordship. I was mention for listing, Lordship. Any day.
Motion.
Admission.
So, next month.
What's a similar prayer, Lord?
Where do you want to withdraw?
Lordship, I get instruction from the client.
Huh?
I get instruction from the petitioner.
But what about this issue?
Lordship,
This repetition is not maintainable actually. Okay, fine. Your name?
K Islam.
Huh?
K Islam.
Over. Mr. K. Islam. K. Islam, Learned Counsel for the petitioner on instructions has submitted that the petitioner desires not to press the petition any further. Accordingly, he pleads that he be permitted to withdraw the present petition. Prayer accepted, registry to prayer accepted, the petition stands. Have you informed the other side? Or they are listed only?
No, Lordship.
Also, in view of the above submission of the Learned Counsel for the petitioner, the present petition stands dismissed on withdrawal. However, it is provided that the steps being taken by the respondent authorities with regard to the eligibility of the private respondents herein with regard to the eligibility of the respondents number 14 to 22 be proceeded with and taken to its logical conclusion.
Lordship, learned counsel eighth bill that is stuck in traffic due to waterlogging, Lordship. The
This is
matter
not
may be
for
taken-
withdrawal.
Withdrawal.
It is for withdrawal, Lordship. It may be taken up at 2.
After some,
At two, my lord.
we can't say.
My lord, I have one VC, my lord, so I will.
You do your VC.
Yes, ma'am.
Item 12.
But Mr. M. Ahmed, learned counsel, prohibition. The petitioner in the present, by way of instituting the present contempt petition, has alleged violation of the directions passed by this court-wide order dated 18/6/2025 in WPC number 6077/2023. Also, issue notice, baki hai ke? Dispense with personal appearance, dispense with 4 weeks.
High level.
Here, the direction is only to the appellate authority.
Yes, my lord.
So why should we issue a notice now to the others? We'll limit it to the appellate authority. But Ms. N.S. Thakuria, learned counsel for the petitioner. Order dated 11/12/2025 in WPC number 4599/2023. Also, considering the considering the nature of the directions passed by this court wide day said order dated 11/12/2025, notice at this stage is issued to only the respondent number 1. Petitioner to baki hai ke? Steps within 2 for the. Considering the nature of the directions passed by this court, why the order dated so. This court at this stage is of the view that notice only upon respondent number 1 would be mandated to be issued. Issue notice to the respondent number 1. Baki.
Oblige you.
Non-appears for the petitioner on call. Registry to list this matter again after 2 weeks on a date to be fixed by. What happened to the appeal?
Lordship, that appeal has been dismissed because Supreme
Dismissed.
Court has already decided the issue in our favor.
That it would be the earlier certificate.
Yes, yes. No, this is not regarding the certificate. This is rounding off the 0.5 marks. It has to be.
Oh,
one.
That you were below by 0.5.
Yes,
So rounding up, it becomes 155.
155.
If it is 155, you are from Assam? Yes, madam.
Yes.
Yes, Lordship.
Yes, sir.
Writ petition, we after this Supreme Court has decided in the favor of the writ petitioner, writ appeals were closed.
This is the Supreme Court judgment, Lord. Para 13, 14 and 15 are the level.
I'll pass the order. Let me go
Okay,
through it.
here, Lordship, what we are praying, already coordinate bench has granted the rounding of.
It has already done.
Yes, what we are
Now,
praying here,
is that appointment.
yes,
We'll direct for your appointment.
yes. Sir.
If other parameters are satisfied.
Lordship.
Learned counsel for the parties. Also, the party, learned counsel for the parties have submitted that the issue arising in the present petition would be covered by the decision of the Honorable Supreme Court in the case of Union of India and others versus Atul Kumar Verma and others. Civil appeal numbers, NOS, bracket of it S. 4423-4426/2026. Also, in view of the above, registry to list this matter again on 28/7/2026 by slip code.
Lordship, item number 54 is connected with this item, so we are not pressing that, Lordship. May close
Item
the
number
contempt.
54,
Yes,
contempt case.
yes. But she may close that, Lordship.
Mr. R. Bora, learned counsel for the petitioner, submits that in view of the institution of a subsequent writ petition
Lordship.
being WPC 106/2026 by the same petitioner, comma, the present contempt petition be closed.
Lordship.
There is not a, you are not there, Rudy.
No, but I have the instruction to appear.
Ms. B. Sharma, learned counsel appearing for the respondents, submits that she has got no objection to the prayer made by the learned counsel for the petitioner. So accordingly, the present contempt petition stands closed. Accordingly, in view of the submissions of the learned counsel for the petitioner, the present contempt petition stands closed.
Lordship, make
This
that
one
the-
I'll pass it on Monday,
Lordship.
Tuesday,
Lordship. Authorized.
28.
My lord, I'm extremely sorry, my lord, item 14, my lord.
No.
1/6/2026, order.
My lord. 1628. My lord, page 10, my lord. Where the relevant
1/6/20, heard Mr. A. Konikor, learned counsel for the petitioner. 1/6/2026 in WPC number 2817/2026. Should notice, sole respondent, sole respondent.
I'm deeply obliged.
Sorry, Lordship, in the withdrawal item 60, I stuck up in the waterlogging, Lordship. So, Lordship, I did not present at that time, Lordship. The respondent is also there for withdrawal, Lordship, item number 66.
Why do you want to withdraw?
Lordship, the appropriate forum is, Lordship, the cap, Lordship, and many persons, similarly seated persons were approached the cap.
Cat.
Principal, yeah.
Mr. A.R. Tabilda, learned counsel, appearing for the petitioner, submits that he may be permitted to withdraw the present petition with liberty to approach the appropriate forum.
Sure.
So, prayer is not objected to by Mr. S.K. Medi, learned CTC, appearing for the respondents.
Sure.
So, in view of the above, the present petition stands dismissed on withdrawal with liberty as prayed.
Not. Obliged, Lordship.
Much obliged.
Wait, please, your Lordship.
Yes, Mr. Mohan.
Your Lordship, kindly, my lord, see page and the impugn order, page 60, my lord. So that is the impugn order, and your Lordship.
You have not been given a copy of the inquiry report.
Not only that, my lord.
Prima facie.
No, not only that. The so cause notice on the basis of which my DP has started, that was not been served even till today.
That's what, it's not here. The notice, show cause not given to you.
My lord, yes, that is not served on me, my lord.
And you had not filed a.
My lord, I have
You
not
have
filed,
not
I have not even appeared.
Not even appeal. This is in the state levels, Government of Assam, ESI.
Yes.
Who is appearing, Mr. Chutia?
I am appearing for 1 and 2, my lord.
Oh, sir. Heard Mr. T.J. Monta, learned senior counsel, assisted by Ms. P. Sharma, learned counsel for the petition. Also heard Mr. T.C. Chutia, learned senior counsel, assisted by Ms. M. Bora, learned government advocate, appearing for the respondents. Oh, sir. The petitioner in the present proceeding has presented a challenge to an order dated 9/4/2025 issued by his disciplinary authority, imposing upon the petitioner a penalty of withholding of 2 increments with cumulative effect. So, the petitioner projects that the departmental proceeding instituted against him was so instituted without any reference being made to him, and the same was also continued without any reference to him. It is submitted that the petitioner was not served with a show cause notice, nor with notices issued by the inquiry officer requiring his presence in the inquiry. Also, issue notice returnable for 4 weeks. Ms. M. Bora, learned government advocate accepts notice on behalf of all
1 and 2, my lord.
of
Oh, my lord.
3 and 4.
3 and 4, my lord, we are not.
You are not there. 1 and 2. Oh, sorry.
24, no?
No formal notice. Petitioner to take steps for service of notice upon the respondents number 3 and 4. But you have not, if that is a separate organization, you have not made that organization a party.
Party.
That, yes, sir.
Yes, I.
So that if required, I'll find. But one thing I'm clarifying, my lord. My basic case is that, my lord, the initial show cause notice dated 28.
Wow, where you given notices of the inquiry?
No, no, yes, separate show cause notice, even that inquiry is no show cause notice, any notice, my lord, including show cause notice dated 20.
Including show cause notice.
Show cause notice, initial show cause notice. Which is on the basis of which the
including the
show cause
show
notice
cause
dated
notice
20.
instituting against him proceedings issued under Rule 9 of the Assam Services
My-
Discipline and Appeal Rules 1964, instituting a department.
My lord, that is my.
Respond number 3 and 4. Steps to be taken. Steps within 3 working days from today. Registry to list this matter again after 4 weeks.
Deep.
Yes, what is your instruction?
We have received instruction, my lord.
That's what I want. Why is
Oh, yes,
the
yes, Malad,
MSCP was not given?
Instruction sent to the other advocate, my lord. That's why instruction received from the competent higher authorities.
Ms. S. Borua was to receive instructions.
We will grant that the petitioners and if necessary pension cases would be resubmitted. My lord, instruction says, my lord, when the instruction will receive the competent higher authorities in the matter, the benefits and the.
I'll go through.
Yes, it has sent with, my lord. And if necessary, you will again send it. My lord. I would text to case, if you have text to case. Hey, text to case as well.
No, the question is, why are you not doing it? Why
But-
is it kept pending?
I could not complete the instruction, my lord.
Huh?
I could not complete the instruction. I don't know, my lord.
You go through it, we'll take it up after some time. These are your retired employees.
Yes.
And they're waiting for such long and you are having your own sweet time. Will not permit. that. Who is the authority to give you senior superintendent of police border? I'll haul him up here and the DGP also if required. Why this casual attitude?
That's why, my lord.
You please go through it, Mr. Balsudi. If you require, you get some further instructions, we'll take it up at 2. Boy, you all of this should cover and take up a little bit for time being. Let them have the instructions. We'll see. Third stagnation increment from 2022.
No cancellation of.
No, this is another matter, Lord.
Oh, sorry. Deepak Nehru.
Barbara- Yes,
Now,
Cancellation.
yes, Lordship.
Yes. What is your instruction?
No, Lordship, this has been cancelled.
Yes.
Become
So,
ineffective,
yeah.
Lordship.
Mr. Dhar had appeared there last day.
Yes,
What is your submission?
in this case, your lordship, that there is another case is pending. So that the matter may be listed along with this case.
Oh, this we are deciding, that will get decided by itself. We had only
No,
adjourned it to.
Original
facilitate-
writ petition, our writ petition is after passing of the impugn order. Before that, we have filed and we
That
have
has become
withdrawn it
infructuous now.
with the liberty to file.
That has become infructuous. Any order passed there?
Yes, in this case, there is an effect that another writ petition was filed challenging the entire selection procedures, and that has been dismissed. And my prayer is let the record may be produced.
We will not. You have not justified, you have not said anything with regard to this grounds that they have assigned. These grounds were with you. You have not even averred in your writ petition to that effect.
No, here, your lordship, so far I know, I may be wrong.
Madam, you proceed with your selection process. We are just requiring these matters to be listed with those two cases. You can proceed. You cannot interfere.
Lordship, unnecessary case is pending, Lordship, as it is becoming infructuous, Lordship.
What is this? Mr. N. Upadhyay, learned counsel for the petitioner submits that the present writ petition be listed along with WPC number 4973/2023. I accept registry to list this matter along with 4973/2023 on 31/7/2026.
Plus, Lordship.
It took ready. Third, stagnation increment.
Yeah, my lord.
We'll have to issue a notice here because they are not there. You are Mr. Kolita, M. Roy.
Kolita.
He is M. Roy. But Mr. M. Roy, learned counsel for the petition. What's up? Issue notice returnable 4 weeks. Petitioner to take steps for issuance of notice upon the respondents by way of speed post steps within 3 working days from today. Also, pendency of the present writ petition shall not be a bar for the respondent bank to consider the grievance of the petitioner and to take steps for redressal of the same.
The fixed date.
4 weeks. You make a mention after 4 weeks. We'll get it. Notice, na, you will have to take steps and all. You make a mention. I'm here.
Yeah.
Transfer order has been issued in violation of the ECI guideline. And I did not complete the 3-year service, and I was transferred in my home district. So
The transfer order is of 16/6.
that is modification. Original 15/3 is remaining.
You have not joined either.
Well, I went to join my Sebumi, but the by virtue of a stay order, he did not.
What happened to that case?
That is pending and listed on 19th of for reply.
19th of?
This one, August. For reply,
No, I can't pass a order here now.
Yeah, definitely.
Other than issuing a notice and tagging this matter with that.
That will do, my lord. My problem is that I am not getting the salary. In that matter, also observation has been issued to pay my salary. But
your salaries.
yes.
Where is that order?
I am suffering.
Where is that order?
That order, my lord. Consider not direction to observation. To consider that. At page 57, my lord. For no fault of mine, I am suffering, my lord.
No, where is that?
So consider the salary aspect also, my lord.
Salary aspect of whom? That person. Nandini Mukherjee.
Yes, I am there.
Okay, there is an order already.
But that has not been considered till date. And another aspect is that, my lord, for no fault I am suffering, my lord.
I know that.
Daughter is at class 10.
See, Mr. How can I stay this year? That will be contrary to the order passed by a coordinate bench in another writ petition.
No, then again, that I understand. Then again, the same issue will be there. Will be tagged. So, my lord, on 19 matter may be tagged on. Let them take instruction on that whether any vacancy because I have specifically stated there are vacancies.
But Mr. S. Nath, counsel for the petition. Also heard Mr. UN Sharma, no. PM Sharma, learned counsel, learned standing counsel?
Elementary education.
Huh?
It's elementary education.
Elementary education department. So, the petitioner hearing was quite an order dated.
15/3/2020.
Where do I get it?
15/3. It is at page 38.
Quite an order dated. (15/3/2026) Your name is at
At page 40, page 51.
2026, transferred and posted from the post of Block Elementary Education Officer, Sunai Educational Block, Kacha, to the post of Block Elementary Education Officer, South Sri Bhumi Educational Block, District Sri Bhumi. So as the petitioner had proceeded to join against the said post, it was found that the incumbent in the said post, who was also subjected to an order of transfer, had approached this court by way of instituting a writ petition being WPC number 1651/2026, and this court, having wide order dated 23/2026, stayed the transfer of the petitioner therein, the petitioner was left without a posting, inasmuch as in the meanwhile the post held by her was also filled up by inasmuch as against the post held by the petitioner at Sonai Educational Block, the incumbent transferred to the said post had already assumed the charge. So the petitioner has already approached this court, highlighting the said position, approached this court by way of instituting a writ petition being WPC number 2591/2026, and the same is pending consideration before this court. So it is in the above background that the respondents, wide notification dated 16/6/2026, has modified the transfer and posting of the petitioner, and she is now being posted to Kamalpur Educational Block, Kamrup District. So the petitioner projects that her daughter is presently pursuing her studies in class 10, and at this juncture, it would not be permissible for the petitioner to move out of, to leave her daughter at her place of study and move to Kamrup to assume the charge of the post of post against which she has been now posted by the said order dated 16/6/2026. It is stated in the that the earlier writ petition filed by the petitioner, as well as the writ petition being WPC number 1651 2026, filed by one Rahimuddin Laswar, is listed on 19/8/2026. So they are all in motion stage, or notices have been issued?
Notice issued.
So in issue notice returnable on 19/8/2026. Mr. Sharma accepts notice on behalf of
Respondent number 1, 2, and 3.
1, 2, and 3, while Ms. MS Bora accepts notice on behalf of respondent number 4. Petitioner to take steps for service of notice upon the respondent number 5 and 6 by way of Mr. A. Ali accepts notice on behalf of Mr. For respondent number 5. Petitioner to take steps for service of notice upon the respondent number 6 by registered post, steps within 2 working days from today. Heard Mr. S. Natarajiman respondent. Also, considering the contentions raised by the petitioner in the present petition, it is provided that till the next returnable date, no coercive action shall be taken against the petition. Further, taken against the petition. Registry to list this matter again on 19/8/2026. Heard Mr. M. Islam, Learned Counsel for the petitioner. Also heard Mr. A.K. Ghosh. Mr. Ghosh is here?
Not.
A.K. Ghosh, Learned Counsel for the Learned Planning Council, Panchayat and Rural Development Department. Also heard Ms.
And Hazarika on behalf of P9 for response.
Also heard Ms. N. Ajarika appearing on behalf of Mr. P. Naik, Learned Standing Council, Finance Department, for the respondent number 7. Yet, we won't allow respondent number 2. Follow DB. Rest of Finance Department. Issue notice, returnable 4 weeks. Also, Mr. A.K. Ghosh accepts notice on behalf of respondent number
1, 4, and
1,
6. 4 and 6.
4, 6, 4, 6. While Ms. M. Bora accepts notice on behalf of respondent number 2 and 5. And Ms. So-and-so, Finance, accepts notice on behalf of respondent number 3 and 7. Complete. No other 4 weeks. Next to 2. Parties are same? Same parties?
Same.
No difference?
No different.
Same order.
Alia, bless you, Lord.
Same. None appears for the petitioner on call. Mr. S. Doctor is present. Mr. S. Doctor is present for the standing council. Revenue and disaster management is present. Mr. S. Doctor is directed to produce the records of the appeal case appeal instituted by the petitioner before the Director of Land Records and Survey, etc., Assam, containing the documents received in the appeal, including the HSLC certificate of the respondent number 6 herein. Registered, this is only Rukmini. Rupnagar.
I'll take.
Registered to list this matter again on Wednesday, 29.
Item number 19. Somehow I missed the matter. Item 19, Lordship. I'm appearing for respondent number 1, Lordship. 19. Notice was issued, Lordship.
It will be as doctor, huh? We have not issued notice.
Lordship.
No, we have not issued notice. Just fixed.
Good morning, sir. I'm petitioner in person, Dr. N. Rajamarthan, sir.
Yes, sir.
Lordship,
Before he starts, Lordship, I may submit.
This is
You have
regarding-
yours.
Sir, today I have come here after getting 1 day CL approval from my controlling officer. Sir, I'm on duty, sir. This is essential because there is an impugned notification from the
Mr.
government.
Martanan, I am with you because the authority who has issued this order at page 38 is the authority who was communicated with regard to your withdrawal of your
Exactly.
VRS
Exactly, sir.
a month ago.
Exactly.
But Mr.
52 days.
Martanan, I'm sorry to
52 days.
say,
Yes.
I don't have the jurisdiction to consider this. Because you are an all India service officer. Your jurisdiction lies before the central.
One more thing, sir. That there is a direction from the government of Assam to the DGP, sir, where they have asked the DGP to stop my salary, and that because of that.
Anything, because all these aspects, you are a officer, all India service officer. As per the act and the decisions of the Supreme Court, unfortunately, we don't have jurisdiction. You will have to go there, skip me, and then go to the division bench. We don't come in until and unless I'm sitting in a division bench. So I permit you to withdraw this. You please approach the
Central Administrative
Tribunal. You have made out a case.
Thank you very much.
Heard Dr. N. Raja Martandan, IPS, appearing in person. Also heard Mr. DJ Das, learned CGC, appearing for the respondents.
1.
So, the petitioner in the present writ petition is a member of the Indian Police Service, and the issue raised in the present writ petition pertains to his service condition. Also, the issue raised in the present writ petition at the first instance would be maintainable before the Central Administrative Tribunal, and as the petitioner is posted in the Assam cadre, Assam wing of the Assam Meghalaya IPS joint cadre, such proceeding would be permissible to be instituted at the first instance before the Central Administrative Tribunal Gauhati bench. The said aspect of the matter on being brought to the notice of the petitioner in person, he has submitted that he be permitted to withdraw the present writ petition with liberty to approach the Central Administrative Tribunal, Gauhati bench, raising the grievances as has been raised by him in the present proceeding. Prayer accepted. Prayer accepted. The present writ petition stands dismissed with a liberty to the petition to approach the Central Administrative Tribunal Gauhati bench for redressal of his grievance.
Including the salary stoppage also, sir.
Everything.
Recovery and salary stoppage, sir, because that's an urgency. That's an urgency,
to approach the Central Administrative Tribunal for praying for grant of reliefs as has been prayed for in the present writ petition.
Thank you, sir.
Much obliged, Lordship.
He has made out a case, but we can't.
Lordship, that's what I was about to submit.
What is this action? You get a withdrawal earlier, then again you.
I'm totally with him, Lordship, in that case. Lordship.
May I please, Your Lordship. The petitioners has been servicing in the institute since 1998, but he has not getting salaries from the 2018, and he.
Yes, Mr. Das, what is happening?
Lordship, I have to take the instructions why they are not getting.
RM Das, heard Mr. R. Porua, learned counsel for the petitioner. Also heard Mr. RM Das, learned standing counsel, Water Resources Department. Mr. Das submits that he would complete his instructions as to why the petitioners herein, although being found are not being released their respective wages with effect from September 2008. So, he submits that he would apprise this court of the same on the next date of listing. So, registered to list this matter again on 29/7/2026.
Lordship, sometime, Lordship.
2008.
Flood is going on, Lordship. Otherwise, Lordship, Upper Assam district is totally flooded.
Why
This is a
is
Tinsukia
it
district.
flooded? You are the person to protect those. What is happening?
We are protecting, Lordship.
You are protecting. Good. This time, that's a great sign. Otherwise, it would have compounded the problem.
At least Lordship should appreciate.
Where are you posted?
My lord, at Dibrugarh division.
Dibrugarh, there is no such problem.
All the officers of the Upper Assam are being deputed in this one, Shivsagar. That's why.
List this matter again on 14/8/2026.
Lordship. Replace.
Yes. What is the marks?
Lordship, that instruction, Lordship, here in this case, I received. I sent it for printing, Lordship. 2 minutes time, Lordship.
Lordship, this matter may kindly be fixed at 2.
When he gets his instructions, we'll take it up. You be it.
Please, Your Lordship. The matter relates to dispute, family mention dispute in between two wives, my lord. I am the first wife, my lord. And there is.
But you are the first wife. Your husband has nominated the second.
Yes, sir. That was done illegally. And my husband was.
Mr. A. Sigda, counsel for the petitioner. Also heard Ms. B. Sharma, learned Standing Counsel, learned CGC appearing for the state respondents. For the railway respondents. Issue notice returnable 4 weeks. Petitioner to Ms. Sharma accepts notice on behalf of respondent number 1, 2, 3, 4, 5, and 7. No formal notice. Parvina, petitioner to take steps for service of notice upon the respondent number 6. Considering the contentions raised by the petitioner, as well as an order passed by the Principal Judge Family Court brought on record as Annexure 7 to the petition. This court in the interim directs that if the pension and pensionary benefits have not been authorized to the respondent number 6, the same be not authorized till the next date of listing.
Deep level.
Please, your lordship. That matter, I have made party the private respondent. I have challenged the order also, and I have made specific environmental phase.
Learned Counsel for the petition. Also heard Ms. P. Thapa, Learned Counsel appearing for the Learned Standing Counsel, Panchayat and your Standing Counsel.
No, lordship.
Appearing on behalf of Mr. A.K. Ghosh, Learned Standing Counsel, Panchayat and Rural Development Department, and Mr. J.K. Goswami, Learned Additional Senior Government Advocate.
For respondent 3.
The petitioner in the present petition has assailed an order dated 7/7/2026 and an order dated 13/7/2026 by which he was 7/7/2026 by which he was within a period of 7 months of his posting as a Gram Rojgar Sahayak in Odali Gam Panchayat under Odali Development Block, transferred and posted to Azarbari Gram Panchayat under Odali Development Block. Also, the petitioner has also challenged an order dated 13/7/2026 by which his transfer to Odali Development Block to Azarbari Gaon Panchayat was modified and the petitioner was posted at Bamungaon Gaon Panchayat. It is the projection of the petitioner that the petitioner has been subjected to repeated orders of transfer, and during the last around 1 year, the petitioner has been transferred as many as 3 times.
No, lordship, within not even completion of 1 year, he has been transferred 3 times.
During the period of last 1 year, the petitioner has been subjected to transfer thrice, transfer and posting thrice.
My lordship, I apologize. Within not even completion of 1 year, he has been
During the last
1 year, not 1 year.
Some submits that the petitioner during the
Not even
period of less than 1 year has been subjected to transfers thrice, transfer and posting thrice. So the petitioner has issued notice returnable 4 weeks. Ms. Thapa accepts notice on behalf of respondent number 1, 2,
4 and 5.
4 and 5. While Mr. J.K. Goswami accepts notice on behalf of respondent number 3. No formal notice, huh? Parvina, raise petitioner to take steps for service of notice upon the respondent number 6 by way of speed post. Speed post. Steps within 3 working days. Heard the Learned Counsel for the parties on the prayer for an interim relief made by the petitioner. Also, on consideration of the contentions raised in the writ petition of the petitioner being subjected to repeated transfers and also finding that the transfer and posting ordered in respect of the petitioner to Azar Bari Gram Panchayat was not permissible to be implemented on account of the government cancelling the, on account of the respondents cancelling the transfer and posting effected in respect of the incumbent holding the post at the relevant point of time. So, the petitioner has made categorical contentions in the petition to the effect that he had signed the attendance register at Odali Gaon Panchayat till 21/7/2026 and had also undertaken all official works attached to him. The petitioner has also projected that he continues to hold the charge of the post at Odali Development Block till date. Also, accordingly, it is in view of the above contentions of the petitioner, the impugned order of transfer dated 7/7/2026, insofar as it concerns the petitioner and the respondent number 6 herein shall remain stayed till the next return.
Apologies, 13/7/2026.
13/7. No.
Is
7/7, you will have to say 7
thereafter 13/7, my lordship, because we
along with the order dated 13/7/2026, insofar as it concerns the petition.
Yes, my lordship.
7/7, insofar as it concerns the petitioner and the respondent number 6. This court further directs that the order dated 13/7/2026, insofar as it concerns the petitioner herein, shall also remain stayed.
Oblige, my
till the
lordship.
next. Yes. Yes, Lordship. 60. Oh, my. Yes, you got the marks.
Yes, Lordship.
What is the name of the Anganwadi center?
Hatiapara village.
Huh?
Hatiapara. 225 Hatiapara.
Advertisement is of?
Advertisement is on 18/12/24.
They say that you are not even a resident of that coverage area of that.
No, Lordship, I'm the resident of this area, Lordship.
What is the marks code? That is the exact direction we wanted from you. She did not participate. She says that she participated in the interview. Who is giving you these instructions?
Lordship, this additional director, Lordship.
Who asked him to give you all this thing? We wanted the marks only. We wanted the marks. Okay, this has come, fine. What is the marks?
Lordship, that aspect, Lordship, I have to
2
check.
o'clock.
Lordship, can it be on tomorrow, Lordship? I will bring.
Tomorrow,
Yes,
10:30.
Lordship, 10:30.
More ঘৰৰ VC ID to deal with.
Oh, sorry. Monday, Lordship. No, no, but my responsibility is to get the instruction. By tomorrow, I can get, Lordship. Because I have
It's a holiday.
no, Lordship, but case will not.
No, tomorrow is a holiday. How will they will also be on holiday? So you
Lordship.
can get the information by 2 today.
4 o'clock, Lordship. 2, it is difficult. 4, Lordship. Monday, Lordship, then. Monday, Lordship.
I again list the matter. 3 o'clock.
3, can it be on 4, Lordship? Because, Lordship, now this time they are busy with the flood issues because they're the women and child welfare, Lordship.
On the prayer of Mr. J.K. Goswami, learned counsel, learned additional senior government advocate, the registrar to list this matter again on 28/7/2020.
Lords.
Mr. Goswami shall complete his instructions in terms of the order dated 27/2026 and apprise this court of the response of the respondents with regard to the query raised by this court by the said order.
By tomorrow, my prayer by tomorrow, Lordship, it is according to the flow of the court, Lordship.
I know that.
Yes,
I know
it is
that.
according to the flow of the court, Lordship. Lordship.
They are not right. Yes, what is your grievance?
Lordship, in the last order, Mr. R.K. Mahanta, Learned Counsel appearing for 3 and 4 was instructed to file affidavit in opposition, but I have not received any service copy of the affidavit as well as.
Then you have not informed them that the matter would be taken up.
No, I did not get that.
How will they know that I'm taking it up?
Yes,
only?
that is also true.
So you can't help it.
Should I wait for?
I don't know when it will reach.
Yeah.
If you can get hold of them, you can bring them. You are appearing for?
Lordship, I am appearing for Aztec, Lordship. We have received the instructions, Lordship. We will file affidavit in this regard, Lordship. I'll do it. Update করিলে না 63.
Aztec is not here. Okay.
Lordship.
When will you file your affidavit?
Lordship, within next week, Lordship.
Why the salaries are not released?
Lordship, salaries are released by the Cotton University, Lordship.
But fund will come from the Aztec. Aztec is not.
You are not an employee of Cotton.
No, actually, it is a
body that
yeah, it is
radio.
It is a center actually. It is a center for radio astronomy. Aztec is supporting for research and development and training program. They established the center in Cotton College.
You were appointed by whom? Cotton College or by?
Initially, I was appointed by the dean, means principal, Cotton College, on behalf of the actually body, on behalf of.
Can I just have that affidavit of you? Well, the appointment. Okay.
Appointment. It is in the page number.
Project fellow.
Yeah. Initially, I was a project fellow in the page number 8.
You are continuing to work as on.
Yeah. Till date, I'm continuing my work.
So why is the funds not being released by you?
Lordship, funds are being released by the government, Lordship. They have stopped the funds, Lordship.
Who are you?
Lordship.
How are you connected then? It's between the government and the Cotton College or government, you and Cotton College?
Government, we and Cotton College.
Why is the government stop the money?
Lordship, that will, in the affidavit will file, Lordship.
You tell me.
Just
man
receive
man
the
is here,
instruction.
huh?
Just receive the instructions. 1 week time, Lordship.
No, today. What is it?
Lordship, there is a order.
Mr.
Yeah.
Lockhart, please. Yes. Why is the amount not being released? What is the reason?
Lordship.
If the reason is genuine, we will dismiss Mr. Lockhart's proceeding.
Lordship.
But you can't just make a person work and not pay him. Mr. Lockhart has a love for astronomy,
Lordship.
but it is also his livelihood.
Lordship, basically,
Which
What
is
are-
the department in the government which is to release the money? Science and Technology.
yes, Lordship.
Huh?
Science and technology.
Who is representing science and technology? Yes,
Respondent
Mr.
number 1.
Goswami. What is why this money is not being released by you? No idea.
Lordship, MOU is signed between the Lordship, Cotton College and Assam Science Technology Environmental Council, Lordship. Government, they have not,
Who is this environmental council?
they have Lordship. 3 and 4 Lordship,
Or this is between them?
between them Lordship. Government is not a picture here, Lordship.
What is this Assam Science and Technology Environmental? What is that body?
That body basically, Lordship, they look after the project and other things, Lordship.
Is it a body created by the government?
That
Yes.
part I
So good. Is it a body created by the government?
Yes, Lordship. Funded by the government.
What is the nature of the funding?
The funds are allocated by the government to run different projects under the Assam Science and Technology, Lordship.
No.
In this case, the funds are stopped, Lordship.
Why? Why is the fund stopped? You entered into an MOU. He will ask the money from you.
Lordship.
Now, if the money is not flowing to you, have you written to the government that this amount is required and why is it being stopped? And what is
Lordship,
the
instructions we have just received, Lordship. Only 1 week time, we will file a detailed affidavit without fail, Lordship.
This unit is in Cotton College. Okay.
Lordship.
You are Mr.
P. Bodley, Lordship.
P. Bodley. Mr. P. Bodley, learned, heard the petitioner in person. Also heard Mr. P. Bodley, learned counsel appearing for the respondents number
3 and 4, Lordship.
3 and 4. Mr. Bodley submits that and the instructions in the matter has been received and he would file the affidavit on behalf of the respondents number 3 and 4 on or before 7/8/2026.
Lordship.
Also, on the Mr. Bodley shall file the said affidavit after a soft copy of the same is sent to the petitioner in person in his email ID. You give him your email ID.
Lordship.
The petitioner in person shall furnish to Mr. Bodley his email ID. Also, thereafter, the petitioner in person is at liberty to file a response to the said affidavit. How long will you take? If they file it by 7th, how long will
After receiving their affidavit.
After 7th, how long will you take? 2
3
weeks?
days only.
Huh?
3 days.
1 week. Granted 1 week time to file a response, the rejoinder there to if so advised. A registry to list this matter again on 19/8/2026. It is provided that no further time shall be granted to the respondent number 3 and 4 to. No, I appointed. Next day, okay. Also.
For R6.
5 and 6. Mr.
Lordship, S Das on behalf of PD9.
Huh?
S Das on behalf of PD9.
Mr. S. Das, Learned Counsel, is present on behalf of the respondent number 5 and 6. 19.8, before that, they will send it to you.
Yes.
And the respondent number 3 and 4 shall, in their affidavit, state as to why the Mr. P. Bodle, on instructions received, has submitted that the payment of the remuneration, that the remuneration of the petitioner was not being released as the government has not released the requisite funds. In the affidavit filed by the respondent number 3 and 4, it should be clarified as to why the government has not released a requisite fund for paying the remuneration of the petition. Whatever it is, let them. He said that government is not releasing.
Memorandum Lordship says that they will provide all facilities and fund Lordship at Cotton University. Cotton University only Lordship provide.
They are only the provider. No, he says government is not realizing, so I put it that. He'll clarify.
Lordship, there is a government order also to release the fund immediately in 108, page number 108.
Mr. Bodler said government is not. So I have just asked you incorporate that.
Obligation.
Lordship, there was a order to take steps on respondent number 2 and 3. And due to our inadvertence, we could not take. However, we have taken the steps yesterday.
We are vacating this order.
No, your Lordship.
Sorry.
We have already taken steps.
Sorry. This is not your thing. You have been asked by even by the office. You have not taken.
We have taken yesterday because somehow we have, due to our inadvertent error, we have.
This is not inadvertence. This is deliberate.
No.
Yes, your office has not taken steps. 25/6/2026 order was passed.
Yes, thereafter.
And then you just.
No. Thereafter, we have instructed our clerk, your Lordship.
That your clerk's inefficiency that we will not permit.
However, your Lordship, last opportunity. Opportunity means we have already taken by a document number 188 of 2026.
Okay, you argue on your interim prayer. We'll see.
Interim prayer, your Lordship, if this is vacated, then they will throw me out.
You are entitled because you have stayed there for the maximum period of time. How long will they?
No, that is okay. But your Lordship will find that in the Lepet Kata unit, not in the Lepet, in the Duliajan unit, there is no provision for a township facility.
They'll give you HRA.
No, they might.
And what is the grounds you have taken in your petition? If you are finding it problem to continue in the state, you must leave the state. That's all.
No.
The grounds that you have taken is not very.
Your Lordship, which one?
I'll show you. Come to page 18, clause 3.
Page 18. Yes.
This is you're alleging something against the society at large. We'll not permit you to.
No, there was an instance of violence.
That was long back, Mr. Counsel.
No. It was recent. I have stated in my writ petition,
Where?
Your Lordship. There was an instance of.
You don't say that.
No, I've stated.
No, you don't say that in your representation. You say because of Jubin Garg's death, there was something and a calm moment. We are not accepting this.
Your Lordship, that is probably inartistic.
If this is your view, you must not be here.
No, Your Lordship.
This is not taken.
No, Your Lordship, we have stated that.
Show me how you were affected by the car movement and by the demise of.
No, not by the car movement.
Yes, you have said here, page 18.
No, there that is in advertence of Your Lordship, the petitioner, Your Lordship.
We don't accept. We accept that. We don't accept that tenor of his, and that's why we find that he is not entitled to it.
Your Lordship, if we don't consider this point 3 also, 1 and 2 is enough.
1 and 2 is not there. We are considering 3.
No, that may not be considered at all.
This is an allegation against the society at large. We will not permit you to do that. Who is he?
He is the great.
Was he invited here?
No.
Huh?
He was working at Lepet Kata.
Was he invited that come to the state of Assam without you?
No,
The
no, no.
organization will
No.
not work.
But there was a particular instance recently, in the month of May, in the unit, wherein some.
Okay, argue on law points. What is your legal right?
Your lordship will find, at.
When was your order of transfer?
Order of transfer was, 21/4/2026. He was transferred.
And what is the maximum time you can retain?
Maximum time is 2 months, which I can retain.
So that is already over.
That is over. However, your lordship may find at page 22 of the accommodation rules, 3.7 clarification part. Page 22. Employees who are posted at other BCPL locations.
Page.
22 of the accommodation rules.
Hmm.
3.7. Employees posted at other BCPL locations who have been allowed permission to retain family at previous place of posting in BCPL township. Those on deputation secondment to government departments, subject to the terms and conditions of deputation, but willing to stay in BCPL township, will be considered for the purpose of allotment of quarters.
Now, show me where you have been permitted to retain retain the family
previous-
at previous place of posting.
Because I'm still, my family is.
Where is that retention permission?
Permission, obviously, that is not
That
there.
is not there. And they have been requiring your thing. 47.
And also considering the bona fide requirement also. Your lordship, I have a wife and 2 children, so they keep on visiting.
There may be somebody else who has
No,
also
no,
a
no,
wife and children.
that point also I have taken, that no one has filled up that particular quarter at Lepetkata. That is still empty and I am still there. And no one has been transferred from Lepetkata to Duliajan.
Is this a central government or a state government?
They is central.
Central. Now, because of you are not taking steps, the matter is getting delayed.
Yesterday we have taken steps.
Why?
Your
Who
lordship.
asked you? You were asked to take steps within 2 days.
That I have accepted, your lordship, that there was some inadvertence.
Okay, you have taken steps through which letter?
Through document number 188 of 2026. Dated
Mr. S.
23.
Dr. Learned Counsel for the petition submits that the steps for service of notice upon the respondent number 2 and 3 was inadvertently not taken. And the same was so taken on
23/7/2026
by
document number
so and so.
188/2026.
Registry to verify this said aspect of the matter and proceed accordingly. The petitioner, considering the nature of the grievance raised by him in the present writ petition, is directed to take steps for service of notice upon the respondent number 2 and 3 by way of Dasti mode routed through the registry of this court within a week from today. The petitioner thereafter shall file an affidavit to that effect on or before 5/8/2026. Registry to list this matter again on 17/8/2026.
My sincere apologies, sir.
Interim order passed. It is provided that in the event it is provided the interim order passed earlier to continue till the next date of listing.
Obliged.
Yes. Yes, Mr. Islam. Mr. Sharma has said he has nothing to say. What do you have to say?
My case, your lordship, against the reduction, your lordship.
That deduction amount is already quantified. You have given your own undertaking that you have, it is under your signature, that 7 lakhs also and so. What is there? The amount that had to go to them went to somebody and you pocketed 1 lakh. Anything more? But Mr. J. Sharma, Learned Counsel for the petitioner in WPC number
7759.
7759 2018 and Mr. S. Islam, Learned Counsel for the petitioner in WPC number 1050-2022. Also heard Mr.
L. Deca.
L. Deca, Learned Counsel appearing for the respondents number
2, 3, 4.
2, 3 and 4 in both the writ petitions. Appearing for the Assam Tea Corporation Limited respondents in both in the above noted writ petition, and also Ms. M.S. A. Chakraborty, Learned Counsel appearing for the Employees Provident Fund Organization respondents in the above noted 2 writ petitions. Hearing concluded, registry to list this matter again. 28/2026 for delivery of orders.
Please. My pleasure, Lord Shumadu. So basically, my lord, the session is, my lord, 1819, and session is over. But the question I have raised, my lord, whether that question still survives.
You said the matter is infructuous.
My lord, exactly. But the question I raised, whether that question still survives. Because you have your rule, you didn't follow the rule, you made recommendation after recommendation, and you filed your affidavit in connection with other case. We held selection. Now you are saying selection is not necessary. Therefore, whether lordship will incline to decide this question, if not, petition has become infructuous.
Mr. A.K. Prothais, Learned Counsel for the petitioner, has submitted that.
Lordship
in view
will kindly make an observation that in appropriate case, that question will be decided.
Submitted that in view of the subsequent developments taking place in the matter after filing of the present writ petition, the issue arising in the present writ petition has been rendered infructuous. Ms. B. Bora, a Learned Standing Counsel, BTC, is present. Also, in view of the submissions of Mr. A.K. Prothais, Learned Counsel for the petitioner, the present writ petition stands closed on being rendered infructuous. I to close query.
Kindly make an observation that the question since survived.
This is infructuous. Whenever that question, I have not decided it on merit, so there is no issue. There will be no constructive res judicata.
Otherwise, tomorrow a question may arise.
If it comes back, if it arises, come and file a review. I'll look into it.
Kindly make an observation.
No, it will not be permissible because I'm not considering it on merits. Why should I make a?
Now, lordship may say the question not decided still survives.
No. Why should I? If it is not decided, it survives automatically.
Lordship, anyways, in similarly situated persons, my lord, the matter has been heard and it was dismissed, my lord. Single benches.
That's why we pointed that out to
and
Mr.
they have preferred writ appeal also and.
Writ appeal also dismissed.
Yes.
I'm not able.
And number 1.
Mr. S. Doctor, Ms. B. Bora, Learned Standing Counsel.
But in their
PTC and Mr. S. Doctor, Learned Standing Counsel, Revenue and Disaster Management Department are present for their respective respondents. Yes, Mr. President.
This matter may take about 2 minutes.
Yes, what happened?
Well, I received the instruction, Lord.
What happened to whether the expiry had occasion?
Lord, that fact, my lord, was not taken into during the pendency of the disciplinary proceeding.
I'm asking you.
My lord, it was not But in paragraph 2, Lord, they have minimum shelf life of 5 years, my lord, but whether beyond 5 years it can work or not, it has to
So
be.
what is the shelf life given? That is the shelf life given.
No, it has to be tested, my lord. It's not that unless the government rejects it, my lord, it cannot be said that it has expired.
No, if it is having a shelf life of 5 years, why does penalty upon the petitioner?
But that plea was not taken by him, my lord.
We are asking you.
And further regarding the shelf life, my lord, 5 years is the period, and beyond that it has to be tested. It remains a government property, my lord.
Where is the penalty imposed upon him?
Page 111. Page 135, 3 is the concluding part, my lord. Paragraph 13.
So in that view of the matter, this penalty with this penalty will mandate because this is a serious penalty.
My lord.
Because this is having a cumulative effect.
Cumulative effect.
Okay. On the prayer of the learned counsel, Mr. H. Gupta, in terms of the query raised by this court-wide order dated 16/7/2026 has placed on record the written instructions received by him from the respondents. The said instructions is kept on record and marked as X for the purpose of identification. A prayer is made on behalf of the learned counsel for the petitioner for an accommodation in the matter on account of personal inconvenience. Prayer accepted. Registry to
My lord.
we don't have, we have enough work there. Registry to list this matter again on 5/5/2026. Matter be not treated as partnered and or tied up matter with this court any further.
Obliged. Yes, from my side, I have the records.
What is that?
Regarding that one particular document, Lordship, whether that was.
Yes.
This matter will pass over for the time being.
On the prayer of the learned counsel for the petitioner, matter stands adjourned for adjourned till 11/8/2026. Matter be not treated as partnered and or tied up matter with this court any further. Yes, next.
Lordship, we have received the records. That document is here, yes.
That is
This document is not a genuine one.
not a genuine one.
In this case, I am unable to collect the petitions for a long.
No, we don't want you to. You tell me how you are
And the-
entitled to maintain a writ petition.
The IIT filed the affidavit.
Forget the affidavit. Generally amongst you, how is this writ petition maintained?
That is too large, but now
It's true, then we are closing it, giving you liberty to approach.
only one time may be given. I can contact the petitioners.
We forget the affidavit. Forget the affidavit. That plea is already raised by this court in an earlier order.
I send them the letter, but that is not returned.
Okay, forget it, Mr. Gugui. Now tell me, how is this writ petition? You are not the employees of IIT.
IIT.
You are employees of some contractor.
Contractor.
You have a contract with them. How can you now pray for this reliefs against the IIT?
I'm not in the case released for IIT Lordship. I'm responding for they.
You want the relief from respond number 4.
As per the affidavit, they stated that they directed.
You forget the affidavit. You are claiming relief in this writ petition against whom?
As well as the IIT and the respondent.
So how are you claiming it from IIT? IIT does not have any contract with you. Does not have any contract with you.
That is too large.
Whatever they have agreed, they are paying it to the respond number 4. If the respond number 4 is not paying you, you take requisite steps as may be mandated in law.
So then dispose it with a liberty to file oppose the competent firm.
Mr. N.J. Gogoi, learned counsel for the petition, after attempting to argue the matter at some length, submits that he be permitted to withdraw the present writ petition for approaching the appropriate forum for redressal of the grievances of the petitioner as raised in the present writ petition. Prayer is not objected to by the learned counsel for the respondents. So accordingly, the present writ petition stands dismissed on withdrawal with liberty as prayed for.
In the delay, maybe.
That is up to you. Section 14 will apply that you make an application there, that this application is pending here. Well, no observation is required. That is already there in the law. You can, when you submit a condonation application, section 14.
The affidavit, they said that they have withheld the amount lost and the IIT.
That is for dumb. That is for respondent number 4 to come to us, not you.
But regularization of suspension period, my lord, despite of the rights of the fourth, my lord, the failed to act.
May please your lordship, because of severe waterlogging, standing council of animal husbandry is not able to come before the honorable court.
Prayer is made on behalf of Ms. M.M. Kotoki. How did you come then?
I live in Rajgarh.
Oh, you are here, you know. A prayer is made on behalf of Ms. M.M. Kotoki, learned, standing counsel, animal husbandry and veterinary, for an adjournment in the matter on the ground that she is prevented from attending court today on account of water logging. Sir P. Kotoki, learned counsel for the petitioner, is present. Registered to list this matter again on 30/7/2026. We'll allow this. You get her instructions. We are allowing this up because there is already an order of this court here.
May it please your lordship. The case of dismissal from service, lordship, after disciplinary proceeding, lordship. We have raised some grounds that, lordship, he was not given proper opportunity, lordship. He was not handled given the documents at proper time, lordship.
What is the proper time?
Lordship, when the charge was
When the charges, when the documents were produced in the inquiry, were copies given to you?
photocopies were given, and I
more is required?
raised an objection that, lordship, some of the documents are not the emails of my.
See, this first two charges, first two allegations of absence. We
Lordship,
find
I
that
informed my authority that.
we find that it is a disproportion. But while we add the next three charges to that on a cumulative reading, we find that tentatively, we find that it cannot be said to be disproportionate. So the only ground now left is to demolish the findings of the inquiry officer for you. That not perverse, not in accordance with law and all those things. And you say that you have been
For my
that absence that was regularized, but they deny it.
Lordship, I have submitted the documents through which I have taken consent from the authority that.
No, the consent, you say that you have brought
I
in
have given
record
email,
documents,
Lordship, that was
190, 187. They have, but in their reply, not supported this. Have you supported this?
Yeah, we are not
Supported this. So what, and why was this document not produced in the inquiry?
Lordship, we have produced 16 documents, those were not recorded.
Where do
By
I get?
inquiry officer not recorded those documents.
No, where do I get that you had returned to the inquiry officer?
Lordship,
That these are the documents I am producing.
Lordship, after inquiry, my reply is there, Annexure 7, Lordship.
Show me the page.
That is page, Lordship. 57.
57.
57 to 89 is my reply.
This is the
After inquiry,
representation against the inquiry report.
Yes, Lordship.
Where have you said that you have brought these documents on record? Okay.
In my reply, I have categorically stated that those 32
Where?
documents, Lordship,
Where?
page 64, your Lordship will find this is concealment of facts from the disciplinary authority, paragraph 10. The inquiry officer on page 3 of his report gave a list of CSO exhibits letters numbering 6.
Madam, show me that you had given this approval of your leave.
Those were not considered by the.
Oh, where have you said in your
that
somewhere?
I have another representation, Lordship, then I
Will
will.
not do. This is the place where you have to say those things, that these are the deprivations. You did not consider my document.
Then, Lordship, I have another leave application is a page 89, Lordship. 189, Lordship.
Okay, show me one first. Mr. Doctor, you also have the records of the inquiry.
The entire inquiry proceedings have been annexed.
Annexed, okay. In your affidavit.
In my
Okay. This will take some time. We'll have
Yes,
to
Lordship.
Heard Miss R. Chaudhary, Learned Senior Counsel, assisted by Miss
S. Begum. Lordship.
S. Begum, Learned Counsel for the petitioner. Also heard Mr. S. Dr. Learned
standing counsel.
Learned Standing Counsel. What is the bank?
TNB.
Punjab and National. Punjab National Bank. Appearing for the respondents. So, the issue arising in the present writ petition would require a detailed hearing. So, accordingly, issue rule. Accordingly, issue rule. Writ petition stands admitted. No formal notice be issued as all the respondents are represented. So, registry to list this matter for hearing. When?
August, Lordship.
August, September, this is 24 matter. November. In the month of November, on a date to be fixed by it. So, no further pleadings are required.
Lordship, if your Lordship allows me, I can file my additional affidavit by bringing on record some
That
representation.
is the only thing which I wanted. And it's okay.
Yeah.
We'll go details into it.
Lord.
Aram se, November, after puja vacations and all, we'll go into this.
Then may I
So
pray,
this will
Lordship,
take
in the
time. So
month
this will
of
take
August,
time.
last part.
This will
Lordship.
take time, madam. This will take time.
Yes, Lordship, on a hearing date, if your Lordship fix.
August will be
August,
difficult. August, September would be difficult. October would be literally motion only. November is the safest time.
October 6th, Lordship. For vacation.
Vacation, I will take it.
Why take the trouble before the week? We'll have it fresh.
Lordship.
Interesting, but.
Since 2024 is.
But madam, you'll have to now go deep into that. You will have to just saying your allegations will not do. You will have to now
Some of the
deal with
representations
the
I have enclosed, Lordship.
deal with the findings per se.
Lordship.
Okay.
Obliged, Lordship.
Obliged.
Yes, madam.
As per last order, Lordship, I have received one instruction.
This instruction is contrary to what we have submitted before this court and recorded in the early order.
A reconstruction of,
Reconstruction will not require the old book, PPO. You will have to do it from the other contemporaneous materials.
yes, Lordship.
So why are you going for this exercise? And you have not set out the dates when you had written to the other authorities. Nothing is here. Who is this man? Joint Secretary.
Lordship, they have written to Baksa, Joint Director Baksa, and accordingly, AG. They have written it. There
AG
are so
said
many
it-
communication.
AG will not have it because AG has written it.
Yes, yes.
So why
In
writing to
2000
AG?
Lordship may given direction to reconstruct the file because
Already,
It's
already
already
direction.
there.
already direction has been
Then
given.
why that has been not complied with?
There,
And you are taking all these steps just to shuck off the responsibility.
no, Lordship,
That's it.
Lordship.
What we do?
Lordship, 1 month time may be
You're
given.
getting a provisional pension.
Yes.
Yes, pension I am getting, but not on the revised.
Revised scale only.
Yes.
Lordship,
We'll give
given
you 197A benefit. Don't worry. With
Lordship,
pension rules.
Lordship, may given 1 month time to reconstruct the file.
No, with this instruction, how can you make that submission? It will be just adjourning the matter. Next date also same thing. I want a categorical thing from your authority in writing that we will complete the construction within 15 days, 20 days, whatever it is.
Lordship,
Uh,
one date may be given.
Miss S. Sharma, Learned Standing Council, Health and Family Welfare Department, submits that the process for getting the requisite approvals and the documents for reconstruction of the service book of the petitioner is underway. She submits that the matter be taken up on 31/7/2026, on which date she shall apprise this court the exact time period that would now be required to reconstruct the file of the petitioner, reconstruct the service book of the petitioner and submit the same to the Office of the Accountant General, Assam, for authorizing to the petitioner his revised scale of pay as well as his revised pension. Also,
Pension on revised payment.
his revised salaries as well as a revised pension. Also, pray accepted, registry to list this matter again on 31/7/26. That much.
Lordship.
May it please your lordship. Matter pertains to suspension lordship, 1/10/2023. And lordship, thereafter a show cause notice was issued. Lordship 9/11/2023, giving the preliminary idea of the case. But
When were you released from your bail term?
yes,
So show cause is within time. Then what happened?
then lordship, no charge sheet or memorandum charge.
What is this? This is the charge sheet.
But
This is the show cause. What happened to the proceedings?
proceeding is still going on, lordship.
What is the stage? Yes, Mr. Goswami, what is the stage of the proceeding?
Lordship, at the time of filing my affidavit, Lordship, it is 25 March, Lordship. Up to that portion, Lordship.
Is her suspension order being reviewed?
That aspect, Lordship, at the present situation, Lordship, I have to take it.
Learned Council for the Mr. J. Handick, Learned Council for the petitioner. You are a lot mondal.
Yes, lordship.
Learned Council appearing for the revenue and disaster management. Mr. R. J. Handick, Learned Standing Council, there is revenue and disaster management, and Mr. J. K. Goswami, Learned additional advocate, additional senior government. Mr. Handick has submitted on instructions that the departmental inquiry against the petitioner has been completed and the inquiry report submitted by the inquiry officer has been forwarded to the government on 25/2026 for concurrence. So he submits that the concurrence from the government being received, the departmental proceedings instituted against the petitioner shall be disposed of. So the respondents, Mr. J.K. Goswami, you are placed under suspension by the district commissioner.
Yeah.
Mr. J.K. Goswami, learned additional senior government advocate shall, on the next date of listing, apprise this court as to whether the suspension order in respect of the petitioner after a departmental proceeding was instituted against him while issuance of a show cause notice dated 9/11/2023 was being reviewed. So, registered to list this matter again on 10/8/2026.
Can you claim the 29th or
Tied up.
some of that? Hide that.
My lord, can it be taken up after some time now?
Today, no. Pleadings.
Pleadings complete.
Complete.
My lord.
Registry, we'll take it up for hearing.
Let it be for admission hearing.
Can it be on an admission hearing, my lord?
It is submitted that the pleadings in the matter is complete and the matter can be taken up for final consideration. So it will go to November.
November, my lord.
Registry to list this matter. Accordingly, registry to list this matter again. September. In the month of September on a date to be fixed by it for admission hearing.
Obliged. Yesterday they have filed an affidavit. I have that.
Government. You want to file a reply?
Not reply, Lordship, it's not necessary because they have not denied regarding cadre strength of senior.
What is the cadre strength?
41.
41.
7%.
So 3 posts.
3 posts.
Who are the men in position?
1.
1. And who is the other 2 who were holding the post?
Other 2 are 1. I have made private respondent.
Ashok Das.
Ashok Das retired.
Ashok Das and Homeswar Deka.
Homeswar Deka also retired.
But they have contended that Homeswar Deka was not holding a post,
According
but
to
some lady was holding the post.
yes, according to them, the Homeswar Deka was promoted to the general post. But I'm not that. I'm on the cadre rank. If cadre rank is, let's say, 41, 3 reserved for S3, and only 1 person is occupying the post of senior division assistant. So I'm entitled for promotion.
Who is the 1 person occupying?
Now, let's see, the private respondent has been promoted to state post.
No, she is not a reserved.
I have made all the person who
I want that who is the person holding the post? Who is the person who is a SC, scheduled caste community candidate in the cadre of SDAA?
Ashok, Lordship.
Ashok is not there. Ashok gone.
Lordship, I'm para 12, Lordship.
Ashok is gone.
Para 12.
Para 12 of your petition.
Lordship. Ashok Das, who belongs to SA category committee, has been promoted to the cadre of district administration. And Homeswar Deka has retired from service after attaining the age of superannuation. Also,
but Homeswar Deka, what is this? Is not the roster point which is shown in this side.
Lordship.
This is the roster point.
This is not roster point.
This is the
This is not roster
community.
point. This is not roster point.
This is community.
Lordship. Homeswar Deka SC has been retired from service after attaining the superannuation. Ashok Kumar Das has been promoted to cadre
So
of
this
district.
is not the roster register.
Not the roster register. There is no roster
So
register.
we have.
There is no roster register that is admitted position by the district administration.
Okay, let us see how many are there. We have Ashok Das, Homeswar Deka, Gopal Horizon.
Now Gopal Horizon, only 1 is there now.
Only Gopal Horizon. No, there is 1 more.
No.
Yes. There is, you come to page 34.
Page 34.
Prakash Sutradhar was promoted against Ashok Kumar Das. And Prakash Sutradhar is a SC. That you will find Prakash Sutradhar's name at page 29, serial number 49.
Lordship. Page 40, page, serial number 49.
Hmm.
They belong to SC.
Hmm.
So if that is also correct, then 2% is there.
So my only thing is, who is this lady projected by the respondents?
They projected that he's, Ashok Das was promoted to general post.
No, not Ashok Das, Homeswar.
Homeswar was promoted to general post. So he was also promoted to general post. But it is admitted position that roster has not been followed. And already law has been settled. When there is a conflict between the roster and the reservation, post of reservation will prevail.
You are getting 3. But the learned counsel for the, it is submitted that an affidavit has been filed by the state respondents yesterday, on the 23/7/2026. However, the same is not on record. Registry to trace and tag the said affidavit along with the records of the said case and list the matter again on when. Whenever you want, give me a date. A short point now.
Short point.
Next day, next
On
next week.
6 or as any you go. 6/8/2026
Apply this.
for admission. Registry to list this matter before any other bench without me. T8. Where is your affidavit?
Lordship, here I have received the instruction, Lordship, he has considered an unreserved candidate because in the application form, he has.
File that affidavit, he will have to
Lordship,
respond.
only on
Mr. S.S. Roy, learned counsel for the petition, for the learned CGC appearing for the respondent, has submitted that the instructions have been received and he would file his affidavit in the matter on or before.
Lordship. Within 14th August. Lordship.
On or before 14/8/2026. Registry to list this matter again. Officer, the petitioner is at liberty to bring on record a rejoinder thereto on or before 21/8/2026. Registry to list this matter again on 26/8/2026.
Published, published.
Who is appearing for that board?
Mr. P.N. Goswami is.
His name is not shown.
No, they are appearing also.
SC/ST.
Oh.
Yes, where is your affidavit?
My lord, files could not be accessed.
And I don't find these days excise, PHE, we have to keep waiting. Very busy.
No, my lords.
Next time onwards, I'm not waiting. I'll ask your officers to be here.
This week, my lords, been short on
We
hands,
don't
my
know.
lords.
Daily it's happening.
My lords, I understand, my lords. We'll take care of it.
Yes.
Lordship, there is some urgency in this case, Lordship, because the persons are retiring and they are in a very.
No, my lord, that fund
That
is already
because-
frozen, my lord.
The
That
fund has been frozen, but that has not been finalized. It was after. Okay. NOC was obtained from all the departments, Lordship. After that, Lordship, the commissioner has passed the impinging order saying that it is a contributor scale. In the trust, Lordship, trust deed itself, the first line itself.
We have seen it. Yes. Don't want to file an affidavit. This
we'll file. Something has come, my lord, because of these issues, my lords. We cannot access the files, my lords. The flood chamber is inundated, my lords.
plan is yesterday, not before that.
My lords. No, still,
This thing was on 19/6.
Yes,
You
my lords,
said
we
that you
understand,
will
my lords,
file.
but we need to retrieve the file also, my lord. We cannot go to chamber, my lords.
How long have you not been able to do?
Last 2 days, my lords.
2 days only.
3 days, my lords.
So 2 days you can't file the affidavit. You have to.
No, affidavit might have also come, so I don't have the knowledge.
No, you
have also
don't
come.
have the time to look into whether it has come, progress, nothing of that sort.
Normally, my lords, when matters are listed 2 days before, 1 day before, check it, my lords. So these I don't have the knowledge.
How long will you want
A week's time, my lords.
to file the affidavit?
Affidavit, as of now, I can say, my lord, it
We
is
want
sent for
the
waiting
affidavit.
also.
And if you're not filing, tell me we are not filing.
Then let it be 10 days, my lords. Because if that access is not done,
Mr. D. Gogoi, learned counsel appearing for the respondent number Respondent number?
Textbook corporation.
Respondent number
One and
two,
two.
1 and 2.
No, only one.
Respondent
Only
number
two.
two.
Only two.
Submits that an affidavit on behalf of the respondents represented by him would be invariably filed on or before 7/8/2026 or 12/8/2026. Petitioner is at liberty to file a rejoinder thereto on or before 21/8/2026. Registrate to list this matter for admission hearing on 28/8/2026. In the event the affidavit is not filed by the respondent number 2 on or before Kimantarik Dishun 12/8/2026, such affidavit would be permissible to be filed by the respondent number 2 only on deposit of an amount of rupees 25,000 with 15,000 with the registry of this court.
Lordship, the interim order.
Interim order was earlier to continue till the next date of this.
Here they have not filed the affidavit, but your lordship, so cause was issued, your lordship. He was suspended on 5/12/2025 with effect from 19.
So cause was issued on?
On your lordship, 11/3/2026, and we received it on 27/3/2026.
Where is that show cause?
Lordship, so cause, I have not annexed since your lordship, after filing of the writ petition, so cause has been issued, your lordship.
So suspension is 5/12.
Lordship, 5/3/12, your lordship. And with effect from 19/11/2025, when she was arrested, your lordship.
Fine, but show cause was issued on?
On your lordship, 11/3/2026. And now we have filed our writ petition on 7/3/2026. That's why we could not annex. And we have received it on 27/3/2026.
And any order passed extending the suspension review?
There is your lordship.
Where is that?
It was dated.
It's not here.
No, that is not, because your lordship, till filing of the writ petition, there was no extension, your lordship.
When was the extension made?
Extension was granted, your lordship, it was only on 7/4/2026.
What is the allegation against you?
Allegation, your lordship, that your lordship, our selection was, your lordship, they say that there is some hanky-panky in our selection, your lordship, and FIR was lost, your lordship, in 2025. Our selection was, your lordship, date back to the year 2013, your lordship. Now, your lordship, I was arrested, your lordship, only next day I was granted bail by the honorable court, your lordship. And I immediately informed the authorities about the release on bail. Now, your lordship, another aspect of the matter is this, your lordship, that out of all the candidates, allegations are there, only those candidates who were, your lordship, arrested, only against them, your lordship, disciplinary proceeding has been started.
When the whole selection is otherwise wished.
Yes, your lordship, that also
Yes,
they cannot do, your lordship.
Goswami.
Well, Lordship, I have to take instruction regarding the.
Who prevented you? This is the 4th day.
Lordship, I will take. I will take, Lordship.
No, is there a time limit that we should mandatorily
No,
provide? Or
Lordship,
there
in
is
the
some...
next week, any date I will take.
Mr. J.K. Goswami, learned counsel appearing for the learned additional senior government advocate appearing for the state respondent submits that he would file an affidavit on where he would receive written instructions with regard to the written instructions with regard to the claims made by the petitioner in the present writ petition and place the same before this court on the next date of listing. Also, prayer accepted. The written instructions be received from a competent authority of the department and placed before this court on the next date of listing. Also, register to list this matter again on 10/8/2026.
45, your lordship, same issue, same
45.
department.
Same.
Only.
Same thing. 45. দুটাতে লিখি দিবা Mr. S. Borthakur, learned senior counsel, along with Mr. P, assisted by Mr. P. Katonia, learned counsel for the petitioner, and Mr. J.K. Goswami are present. তাৰপিছত এইখিনি লিখিবা।
Deeply observed.
Otherwise, Lordship, in case of 45, Lordship, we have, we received the instruction and sent for vetting, Lordship.
Okay, 45 লিখিবি। Mr. Goswami,
Sent for vetting of
submits that the affidavit is ready and the same would be filed on or before 7/8/2026. আগৰটো কেতিয়া date কিমান date দিছো?
10.
10/8. Registry to list this matter again on 10/8/2026.
Lords.
Deeply observed.
Second to এইটো লিখি দিছো।
আহিছে।
44, my lord, the widow before your lordship, who received a pension accrued on behalf of on account of death of her husband, my lord. There was a dispute regarding, my lord, her second wife or first wife, my lord, but there was a proceeding in, my lord, so this
Yes.
district court, my lord.
Then what happened in the district court?
My lords, it has upheld my position as the first only legal wife, my lords. Page 36, my lords.
35.
35 and 36.
You are Sunita Das.
I am Pratima Das.
Pratima Das. Sunita Das, Pratima Das is the plaintiff.
Yes.
So plaintiff has been held to be the legally married wife.
Legally married. And that is of 2018, my lords. Okay, I see. Which is paisa.
You have not received your
My lord,
instruction.
instruction I have received, my lord.
What is there? Tell me.
That is the return to the return rights, though on the basis of data, my lord, my submission. Pension is going to release within 10-20 days, my lord,
Okay.
in
Miss-
favor of
all
the
right.
man.
Miss A. Gayan, learned counsel, learned CGC appearing for the respondent submits that the pension and pensionary benefits to the petitioner.
Petitioner, my lord.
Then we'll dispose it of.
Yes, my lord, that is. Discuss করে দিন।
The present writ petition, I've heard Mr. D. Gogoi, learned counsel for the petition. Also heard Ms. A. Gayan, learned CGC appearing for the respondents. Also. The petition, by way of instituting the present writ petition, has prayed for a direction upon the respondent authorities to authorize to her family pension and other pensionary benefits. Your husband died before retirement or after retirement?
After retirement.
After retirement. Where do I get it?
What is it? It's not annexed, man.
Here,
It's not mentioned. But from knowledge, my lord, I'm saying, my lord.
but here that is mentioned, my lord, in this office.
Time of
Yes,
serve, na?
yes. At the time of retirement, he had submitted a family declaration. That is there in paragraph.
Family declaration, the name of?
Name of
Name of Sumita Das.
Sunita Das, but as per court order, my lord, we are going decide to release the amount to the petitioner.
So, no, the petitioner, the petitioner in the writ petition has projected that she is the wife of late Subut Chandra Das, who was an ex-senior trackman, in the railways. The husband of the petitioner had retired from his services on 3/5/2016. Also, the husband of the petitioner at the time of his retirement submitted a family declaration and therein did not incorporate the name of the petitioner as his wife. Also, late Subodh Chandra, the husband of the petitioner, passed on, on 22/10/2018. One Sumita Das, the name of, there is a private respondent.
Yes, my lord.
Not come.
Already.
Oh, has come.
Has come, my lord, let me see, has appeared.
None has appeared for the respondent number 4. Will you query video call?
Yeah, we have.
None has appeared for the respondent. Family pension was, of course, the petitioner had been made a family in the family declaration made by him. The husband of the petitioner, in the family declaration made by him, having incorporated the name of the respondent number 4, that is Sunita Das, as his nominee, comma, the respondent authorities had authorized to set Sunita Das the family pension in the matter. Further, appointment on compassionate ground was also extended to the son. Is Suman Das is your son?
First 3 sons are mine.
Suman Das.
Yes. Fourth one is.
Oh, forget the fourth one. Who is Suman Das? Your son?
No, compassionate who is appointed, he is the son of the second wife.
Including the appointment of one son of the respondent number 4, Suman Das, on compassionate grounds. First, being aggrieved, the petitioner had instituted a title suit, being title suit number 93 of 2018 before the Learned Court of Munsif.
No, my lord, civil judge, junior division Hujai.
A civil judge, junior division Hujai, seeking a declaration with regard to her marital status. The said title suit was decreed in favor of the petitioner, and therein it was held that the petitioner herein is the legally married wife of late Subodh Chandra Das.
Page
36.
Also, Ms. A. Gayan, learned CGC, on instructions have submitted that in view of the decree passed by the learned trial court in title suit number 93/2018, the family pension drawn by the respondent number 4 was discontinued with effect from 21/20/25, and a family pension in favor of the petitioner herein has been duly sanctioned and by the competent authority and forwarded to the accounts department for disbursement. She submits that the amounts involved would now be disbursed to the petitioner within an outer limit of 2 weeks from today.
2 weeks waiting.
Also, the said authorization of family pension to the petitioner is stated to have been made with effect from 21/1/2025. Also, in view of the said submissions of Ms. A. Gayan made by Ms. In view of the submissions made by Ms. A. Gayan, learned CGC, Mr. Gogoi has fairly submitted that the grievances raised by the petitioner in the present writ petition stands redressed, and the writ petition may be closed with a direction to the respondent authorities to expeditiously disburse to the petitioner her due family pension. Also, in view of the above discussion, this court directs the railway authority, the respondent authorities to release to the petitioner her due family pension with effect from 21/1/2025 as undertaken before, as undertaken to be so authorized by the respondents and intimated to this court by Ms. A. Gaim, Learned CGC. The said amount the areas involved be released to the petitioner within a period of 2 weeks from today. With the above observations and directions, the present petition stands dismissed.
Can you make it 20 days, madam?
20
That is
days.
because-
Okay, 30 days.
30
30
days.
days.
Yes.
All right,
God
madam.
bless.
You take this.
Yes.
Thank you.
Dispose. With the above observations and directions, the present petition.
All right.
Lord, state was expected to respond to the petition, but nothing has come forth. The question is whether the appointment letter can be withheld for no reason at all. After undergoing the entire process of selection, and I have been congratulated for being selected, I was asked to come and collect the appointment letter in the ceremonial distribution function. I came, then they didn't.
You belong to the T-tribe community.
T-types community, reserved community.
Yes, Mr. Goswami, what is the issue?
Lordship, that's why, Lordship, I am charging that letter sent but not received. But I have to remind, and next week, Lordship, I will take.
The time is passing by,
No,
and
Lordship.
my faith is hanging
Yes,
in
Lordship.
balance.
In the next,
All those who have joined, already joined, to kindly
Training
consider my plight.
completed, join now, he'll have to undergo training.
Lordship, next week, Lordship, any date, Lordship, I will.
Let that be the my respectful submission.
Mr. J.K. Goswami, prays that without fail, he would apprise this court, upon completion of instructions, as to the reason why the petitioner has not been issued with a order of appointment after his selection for the post of constable bracketed AB. Also, to facilitate the in view of the submissions made by Mr. Goswami, this court directs the registry to list this matter again on 5/8/2026. Also, Mr. Goswami shall, on the next date of listing, complete his instructions and apprise this court as to why the petition in pursuance to his selection has not been issued an order of appointment as against the post of constable bracketed AB. In the event the said instructions are not forthcoming on the next date of listing, this court would consider issuance of directions for the personal appearance of the
Lordship, I will apprise. I will.
chairperson, state level police recruitment board, as well as the who is to appoint now? Director General.
Director.
Chairperson.
Chairperson has made the selection.
To direct
The
the
constable.
appearance of a competent person to assist this court in disposal of the present petition.
District party no,
Competent person, competent authority.
competent.
SP, Lordship, Lordship, only one thing is required, that why his appointment
That
letter.
is what we are waiting for 3 days.
Lordship, personal appearance action may not be required, Lordship. Next day, Lordship, I will apprise this.
No, for 3 days, they have not responded to you.
Lordship, but the specific letter has not gone from our part.
Last
Lordship.
line to cut.
Yes.
So that's why then, these are the lapses that the petitioners are suffering.
No.
I won't blame them, but then it is definitely a duty on the part of everybody.
Yes.
See, they sometimes don't like it, but I get angry because I get angry Because the matter is delayed, petitioner is suffering, my staff is suffering.
Exactly.
Every file moving
I've
around, it's
noticed.
not, I have gone, I've seen, it's not easy. Not very easy.
That's the reason people are losing faith on this system.
In the
We
last,
must be careful enough and mindful of that. People in general having lost confidence on these institutions because of this delay.
No.
And we are all responsible for that. Well, I take it on my own.
Mr. Bohonto is around, people will not lose faith.
No, my lord. Lordship will appreciate it. Going by the scenario prevailing. And that's why my anxiety is that shouldn't be allowed to happen. We must, everybody be careful enough.
I know when Mr. Monto is appearing, he will ensure that it does not happen.
Well,
That much faith I have.
despite my best effort and your lordship's best effort, we fail to receive.
No, we will. There will be a way out. Don't worry. But keep doing that.
What I want to
Keep
indicate
doing what
is,
you're doing.
well, what I indicate only to see that everyone who are involved here should be at least do their best in this regard.
That's
In
true.
our part.
Let's see, I'm doing my best. Let's see how far we can.
Lordship, my senior counsel should not be worried. Interim protection is there. in
Lord,
his favor.
that
Lordship.
protection
But-
is
but-
protection
but-
is nothing.
Lordship, but
See, this boy is a member of a backward
yes, Lordship,
community.
do admit
Huh?
on that line,
This
Lordship,
job for him,
yes,
him,
government is
the whole
always
community is a dream.
Yes.
yes, Lordship,
Ah,
government is
Maybe we can't perceive what their expectation of
Exactly.
this job is. We
Yes.
can't perceive
Lordship,
because
do admit it.
Exactly.
we may not have that need.
Exactly.
Therefore, the government
So we
given
face them.
special protection, Lordship.
We
Okay,
face
we'll
them.
see. We'll see, Mister. Next.
Lordship, even
MLA
even in the first order, Lordship, it is 29/05/2020. This specific direction, which today your Lordship given, that was not directed, Lordship. This specific.
Not necessarily because you were given an
Yeah,
opportunity.
yes, Lordship. Yes,
But you have failed on
but-
three
but
occasions.
we
I
submitted.
don't understand.
we-
I'm not hearing, Mr. Goswami.
Yes.
I've lost my ears hearing for a
This
few
is the
minutes.
order, Lordship. Last
I've
order.
lost it. I can't appreciate this.
No, Lordship.
I can't appreciate it.
Exactly.
Anyway, Lordship,
Exactly.
I will, anyway, Lordship, I will
Get it.
bring.
Even.
Yes, I
With
will
your,
bring.
on your request, I have deleted.
Yes, your Lordship. I will bring.
Well, nonetheless, the interim
no,
order
I will-
earlier passed. and
Interim order to continue
Ah,
until
it is-
further orders.
Obliged.
Obliged to touch. 47.
Please, your lordship.
Wait, to move it in.
People is up to.
May I plead, your lordship? Lordship, we have received extra copies only on last Friday, your lordship. Lordship, we got the pairwise comments, your lordship. Need
This
2 weeks
RM
time,
Deka,
your
Learned
lordship.
Council, Learned Standing Council,
Dima Hasao, your lordship.
Dima Hasa Autonomous Council submits that the instructions in the matter has been received by her. And the affidavit on behalf of the respondents represented by her would be filed on or before, whenever you want to tell.
Your lordship, after 2 weeks, any date.
Lordship, can it be a short date, lordship, considering the nature of the case?
Why did you not give the copies, writ petition copies?
Lordship,
You only gave last Friday.
no, lordship, I had served, but like, there were some clerical issues, lord.
Whoever it is, they did not reach her. So please don't make that statement today.
Lordship,
Yes,
On 19th of August.
by 21st, 21/8/2026, registered to list this matter again on 28/8/2026.
Obliged.
Mr. R. Boro, Learned Standing Council, AG is present. Huh? PWD, Namtulu.
Obliged, your lordship.
T8.
No, in this, we have received instructions, my lord, 3 weeks time may be granted, we'll file our affidavit.
Returnable date
My lord,
on the prayer of Mr.
R.B. Goswami.
R.P. Goswami, Learned Standing Council, Transport Department, registered to list this matter again after 4 weeks. Mr. Goswami, in the meanwhile, shall invariably file the affidavit on behalf of the respondents represented by. So
Take
registered to
verification.
list this matter again after 4 weeks.
Date will fix, my lord. That is regarding pension.
That affidavit be filed, we'll see. Anything more to submit? A day, Learned Counsel for the petitioner. At length. Hearing concluded. Registry to list this matter again. At a date, yeah, delivery coming. Today it will not be possible because I have 5 orders already. We'll pass the orders, don't worry. Pass and oil, na? Pass in of 28/7/2026 for delivery of orders. We'll bring you back, don't worry. We'll bring you here. We'll direct them to post you back. 208.
May I please, your lord?
Yes,
My lord,
Mr.
here what has happened, my lord, in fact, I have filed an additional affidavit, my lord, to show that, my lord, without even affording to inspect the documents and file my WS, my lord, what they have done, they have appointed the inquiry officer. They are putting the cart before the horse. Now, these I have brought on record, my lord, by way of an additional affidavit. That is not on record. My lord, may I pray, lordship will take up on Tuesday, my lord.
Next week in post.
Lordship may kindly give us some time to file affidavit, my lord. I will receive the instruction, my lord.
My lord, if your
That
lordship
take
takes
some
up, my
time.
lord, this affidavit, for a moment, my lord,
There is an interim order.
Yes,
there is an
Lordship.
interim order, my lord, but the problem is, your lordship will see, my lord, the honorable court had given them liberty to proceed, my lord, with the inquiry.
Okay, let them proceed, but they will not conclude.
Yes, correct, my lord, they can proceed, but what has happened now, before, my lord, inspection of the documents and before, my lord, my filing of the WS, they have appointed the inquiry officer, my lord.
Okay,
this
fine.
is in total violation of 9394, my lord.
Okay, this court not having stopped it. Those are violations. You raise your objection, participate, come back. Let these sins accumulate. Then on the judgment day, we will see how it can be done.
If it explodes, my lord, good for me.
It will explode.
But I
That's
don't know,
it.
my lord, what will happen eventually.
Okay. It is submitted that an additional affidavit has been filed by the petitioner. However, the same is not on record. Registry to list this matter again on 3/8/2026 along with the said additional affidavit. The respondents in the meanwhile may also file
Lordship,
their
some more.
affidavit. Then we'll not say anything. Also, registry to list this matter again. We'll have to consider that aspect. Let it come on 3/8/2026.
My lord, the interim order passed.
Interim order passed earlier to continue till the next date of this.
Deeply obliged.
Obliged.
দুটা বাকি আছে নেকি? None appears for the petitioner even on second call. Registry to list this matter again after the no. Ratiba nasil nahi kuno. At 2:18.
May I please, your lordship. My lord, on the same subject matter, lordship, there are batch of writ petitions pending, lordship. Lordship, the petitioners are appeared, lordship.
What is your grievance here?
My lordship, my grievance is that our grievance is that, lordship, without publishing any merit list.
They have published a select list. Where is the select list? Where is the requirement in law that the marks have to be published along with it?
My lord,
Where are the private respondents? You have made them private parties here.
No private respondent, because lordship.
So today we have to interfere. You file an RTI. You get your information.
No, my lord, in the.
Is this court the public information officer?
My lord, because on the same issue, lordship, already
Maybe
bench
this
of
is
writ
before
petition is
me.
pending,
I
lordship.
don't know what is that? This,
Lordship, only
any decisions taken in those?
no decision still pending,
So
lordship.
that is not binding on me.
Yeah,
Now tell me, what is your grievance?
lordship, our
There
grievance,
is, I don't find any grievance here.
lordship, without publishing any merit list, lordship.
Merit list, select list was not published.
Not published, lordship.
Select list not published.
Select list not published, lordship. Only
Here.
on, yes, lordship. Only we have seen the on online mode, lordship, that you are not selected. Better luck.
Something was done. Something was done.
Lordship, that has to be determined, lordship.
Show me that you have the marks. You are just, this is just a roving inquiry. What you are
Lordship,
seeking here.
Lordship,
Nothing
after,
more, nothing
after
less.
qualifying all the tests, lordship, we allowed to appear in the Bible.
Show me that you had the marks. You were within the cutoff marks. All
No,
these things
cut
you.
mark was not published, lordship. That is our grievance, lord.
You file an RTI, get those details. Why should we proceed without any material? And tomorrow we interfere. Where are the persons who have been selected? They are not before us.
Yes, lordship, but the fact is that, lordship, 200.
Okay, I accept your prayer. I allow your writ petition. What relief can I give you?
My lord, in early other writ petitions, lordship, there is an interim.
Mister, I'm not concerned with the other writ petitions. They are not with me. This is the only writ petition.
Yes,
before me.
lordship, but regarding lordship, other selected candidates, lordship, as your lordship queries, lordship, that other selected candidates, lordship, there are already 202 posts kept vacant, lordship, as per this interim order of this honorable court, lordship. That was not declared, lordship. So there are 202 posts still.
That is
given.
for some other purpose. In some other writ petition, it has been kept. But for your writ petition to go ahead, where is the parties who would be affected? What is the ground? How many marks? Give me these details.
Lordship,
I'm not here to find out details for you, am I?
lordship, your lordship may kindly see
I'm
paragraph.
not here to find out facts for you.
Lordship, your lordship may kindly see paragraph 4 of my writ petitions, lordship.
4.
Yes, lordship. Because only those marks we provided to me, provided to us, lordship. That petition number 1, lordship, obtained 52.42 marks out of.
Have you submitted an RTA asking for the cutoff mark?
No, no RTA was.
Is there any requirement in law that this has to be published?
Lordship, because lordship, in the advertisement itself, lordship.
Just show me the provision. Rest I'll take care. This is your PST marks.
PST marks, lordship.
Or this is the written examination or what?
Written examination.
Written exam.
Yes. Written test. The page 31, it is 13, column 13, Roman 13.
Page?
31. Written test. Written 100 marks, multiple choice type question. Be answered.
And the selection will be on the basis of?
Both, lordship.
Physical efficiency, written, academic and oral.
Yes,
So 100.
Yes.
So where is your marks for this?
Lordship, because marks was for written test, lordship, marks was not provided to us. Just only, lordship, we qualified in the written test. That accordingly.
What is para 4?
Paragraph 4 regarding, lordship,
On the prayer of the learned counsel.
Physical efficiency test.
Registry to list this matter again after 2 weeks on a date to be fixed by. You take your chance.
This is a contempt case. Here,
I have received the appointment. Only one issue, while this proceeding was going on, they had preferred a writ appeal. In writ appeal, some direction is there. Concluding paragraph at the last page, some notional thing has been granted to me.
the last line of the division bench order, lordship. After joining, all this will be considered by the department.
But notionally, you will have to fix it.
Definitely, Lordship.
You have fixed it, no?
No, Lord, because he has allotted the CRPF by the SCC, then he.
You are for SSC,
I am for the CRPF and SCC both.
both. Then why the effect was not given?
Lordship, because he is yet to join, because
Why
Lordship.
have you not joined?
No, now I have received.
He-
I
Lordship,
actually, I was also.
appointment letter has been
Yes, yes,
received
actually.
recently.
Madam. So I just wanted
We'll
to.
provide for that.
Yes, actually, that will do.
Mr. D. Gogoi, learned counsel appearing for the for the petition has submitted that that in pursuance to the directions passed by the wide order dated
Order to carry.
Lordship,
order dated 25/6/2015. Gazizur Rahman.
Gajir Rahman.
Lords.
Yes.
By judgment and order dated 25/6/2015, comma, in WPC number 861/2014, the petitioner has been appointed as constable, comma, general duty dash 2012 bracket over in CRPF. Mr. Gogoi submits that the said decision of the coordinate bench of this court was carried upon appeal by the respondents by way of instituting writ appeal being writ appeal number 9/2018. The division bench of this court, wide order dated 13/9/2023, had dismissed the said writ appeal. However, it was provided therein that the appointment, if effected in respect of the petitioner, shall be made effective from the date on which candidates lower in merit to him were appointed in service. It was further clarified that the petitioner shall be entitled to only notional monetary benefits from the date on which such candidates were appointed, and actual financial benefits shall accrue to the petitioner from the date he joins the post. Mr. S.C. Cal, learned counsel for the respondents, has clarified that the petitioner, on joining his services in pursuance to the offer of appointment issued to him on 13/7/2026, comma, the directions passed by the division bench of this court in wide judgment and order dated 13/9/2023 in the appeal number 9/2018 shall be complied with. Right?
Right.
So, in view of the above, and there be no willful and or deliberate violations of the directions passed by this court, comma, this court, in view of the appointment being effected in respect of the petitioner, wide a communication dated 13/7/2026, as well as the submissions of Mr. S.C. Cal, learned counsel for the respondents, proceed to close the present contempt petition. In the event the petitioner, after joining his services, has any grievance with regard to the manner in which his pay and allowances have been so fixed, it will be open to the petitioner to approach this court by way of instituting appropriate proceedings. A copy of the order dated 13/7/2026 as furnished by Mr. S.C. Cal, learned counsel for the respondents, is kept on record and marked as X for the purpose.
Macho.
Yes, Your Lordship, in this matter, I pray for 1 week time, as we have to file an IA.
Miss
P. Talukdar.
P. Talukdar, learned counsel for the petitioner, submits that she be granted 4 weeks time to
4 weeks,
file
1
an
week.
additional file an interlocutory application in the matter for impleading the present incumbents. File an interlocutory application. So prayer accepted, registry to list this 3 weeks, Kodia, 3 weeks. Madam, Kotoki is not here. This contempt matters will not be cannot be taken up. You want an adjournment? Huh? No, you want an adjournment in this?
Yes, yes, my lord.
Who is the petitioner? 56, 57?
No, 50.
55
Hmm,
to
you're very
60.
good.
Lord.
Huh?
55 to 60. Contempt.
55 to 60.
Respondent 1.
Okay, 2 o'clock we'll see. Kata mana saya kurang mau tadi. Yes. Yes.
Lordship, so far, Lordship, I go through the instruction, Lordship. It is not up to the mark, Lordship, as per the.
Why aren't they
direction.
sending such instructions? Our orders were very clear.
Lordship, that's why, Lordship, although Lordship, the senior superintendent of police is not the authority to.
He is not the authority.
Yes, Lordship, therefore, I have to take up the matter with the proper.
Just getting delayed. Next time we don't get the information, we'll ask the DGP to
Lordship,
be here too.
I will.
Mr. J.K. Goswami, learned additional senior government advocate, has submitted that the instructions received by him is not complete and would not answer the query raised by this court-wide order dated 13/7/20. Accordingly, he prays that the matter be taken up on when?
Lordship, 1st of August, Lordship, first week of August.
On 3/8/2026, on which date, 5/8/2026, on which date he shall produce the updated instructions.
Obliged, obliged.
How to know? Thank you, John.
It is your lordship. My lord, they are willfully not complying the order. Kindly see order dated 9/1/26, my lord own order. Disability pension, my lord. Direction was given, my lord, within 6 months. Till today, my lord, they are taking time again and again and again, my lord. And 18/3 also, my lord, 26 order.
Yes, Mr. Chaudhary, what has happened?
Lordship, we are supposed to file the affidavit.
Sorry,
Yes, I can understand the Lordship, but
So
let me clarify the reason
who
for
is
not.
the respondent?
Let
He is
me-
appearing.
No,
When?
Lordship, let me clarify the reason, Lordship. This concerned person, Director General, because of some operational exigency, he is out of station. He was supposed
Okay,
to,
when is he coming back?
that information.
This order was of 22/6. You
Exactly,
had
Lordship.
taken time as last chance.
Exactly, Lordship.
So he is appearing before this court for
Yep.
drawal of contempt proceedings when? Or we are drawing up contempt proceedings today,
Lordship,
asking the Commissioner of Police to arrest him and bring
no,
him here.
affidavit is ready, Lordship. He
We
was
know,
supposed, he
we
was supposed.
compliance. We don't want your affidavit. We want your compliance.
No,
You have not.
The difficulty is that we have passed a speaking order saying that he is otherwise not entitled for the disability pension.
Have you communicated to him?
Yes, on the last occasion also it has been
No,
communicated.
no. Have you communicated the order to him?
Exactly, Lordship. This communication is there.
Yes. What is there in the order?
This is the order, Lordship. I
Show me.
can give a copy of this order. Lordship.
My lord, kindly see the court order, my lord. Page 9. What is the need, my lord, speaking order?
In the last paragraph, Lordship, it has been mentioned. Director General has passed an order with regard to them.
Okay, madam. Now that they have passed an order on your consideration, this letter that was issued by the legal cell, that was said to be issued unauthorizedly without any, what do you call that, approval of the authorities.
Yes.
So now that this order has come, you challenge this, we'll see.
My
Can't
lord,
help it. Can't help it.
as kindly
There is
said
no willful and deliberate violation.
in order, my lord.
Court order is because of that letter. That letter now has been invalidated.
That was a part of my writ petition, my lord. He was present in that day, my lord. That was disposed of in his presence, my lord.
Mr. SP Chaudhary, we are closing it.
Yes, Lordship.
You challenge this. Miss S. Bora, Learned Counsel for the petition. Also heard Mr. SP Chaudhary, Learned Counsel appearing for the respondents. The present contempt petition has been instituted alleging violation of the directions passed by this court-wide order dated 18/11/2022, WPC number 5981/2022. This court-wide said order dated 18/11/2024 had disposed of the writ petition filed by the petitioner hearing, at the stage by providing that the claim of the petitioner for grant of disability pension be processed as expeditiously as possible by including the same in the next batch of claims, and to disperse the amount payable to the petitioner within a period of 6 months, along with arrears and penalty. The said direction was passed by this court basing on a communication dated 9/10/2024 issued by the officer in charge legal cell to the petitioner. Also, Mr. Chaudhary has placed on record, has furnished a copy of a speaking order issued by the Director General of Assam Rifles, wherein on a consideration of the directions passed by this court, the entitlement of the petitioner to disability pension was assessed. Also, on such assessment, it was held that the petitioner was not eligible for grant of disability pension, as his disability was not covered by the provisions under Rule 3(4) of the Central Civil Service (Extraordinary Pension) over 1939, Rules 1939. Also, the speaking order further refers to the communication dated 9/10/2024 and it was recorded there that the said communication was issued by the dealing officer without consideration of the relevant rules, application of mine, and in dereliction of his duties, for which appropriate proceedings have been taken against him. Also, in view of the said speaking order and the contentions raised therein, this court is of the considered view that there is no willful and deliberate violations of the directions passed by this court-wide order dated 18/11/2024 in WPC number 5981/2024. Accordingly, the present contempt petition stands closed. Also, however, the petitioner is granted liberty to present a challenge to the said speaking order dated 29/5/2026 by way of instituting an appropriate application. Full stop. A copy of the order dated so and so 29/5/2026 is kept on record and marked as X for the purpose of identification.
Always.
None appears for the petition on call. registry to list this matter again after 4 weeks on a date to be fixed by.
Can we see May 18th order?
Well, after that, the file was processed and put up before the Honorable Minister.
Yes.
After that, my lord, everything was done from our part, my lords, and the file was put up before the minister.
Oh.
Concerned minister. The minister sends this file to for the Advocate General to put his views, my lords. Otherwise, lordship will find the department is inclined to do everything. Everything is ready.
No, why this circuitous manner? Have you filed an appeal against the order?
No, my lords, but lordship will see the communication.
We are not seeing. We only want, whatever disciplinary actions.
No, my
that
lord,
we have
my
to take.
department, my officers have done whatever they have can. They have convinced, my lords.
Any person in the meantime he is hindering with the implementation of the order, he automatically comes in.
My lord,
You tell us who is implementing, who is entering, we will put him.
My lord, kindly see that communication, my lords.
Deputy. 5/2/25, this order.
Yes. Lordship will see that it indicates, my lords, what is the back with the minor department. Department wants it to become, wants to comply, my lords.
Oh, now you have sent it to the Advocate General.
Yes, my lord.
Okay,
The
get
minister.
it. We'll give you 2 weeks time. Get his views.
My lords.
But this cannot wait.
I spoke with Mr. Nayak. If his office is dealing with it, my lords. So they said they are preparing the reply.
Okay, fine. Mr. Gogoi, Learned Counsel appearing for the respondents has submitted that the department for a purpose of release to the petitioner his regular pension and other pensionary benefits, and also for regularizing the period of service, had sought the opinion of the Learned Advocate General, Government of Assam, and he submits that the opinion being so received, the order violation of which is alleged in the present writ petition would be complied with. He submits that he be granted time till 12/8/2026 for updating, for furnishing updated instructions.
I only hope that my lord, I will get it before I perish. I'm a
It
cancer
is
patient,
provided
my lord.
that the directions passed by this court having remained, in the event remains unimplemented on the next date, this court would proceed further with the notices issued on 18/5/2026 and would pass directions requiring the presence of the contemners before this court on a date to be so fixed for the purpose. This is all the ways how do you delay the things.
I have convinced everybody is ready. File was put up before the minister, he sends it to the AG.
February 2025 orders. Now they are sending it.
55 to 60 लिखी हुई। On the prayer of Miss M.M. Kotoki, learned counsel for the a prayer is made on behalf of Miss M.M. Kotoki, learned counsel for the respondents for an adjournment in the matter on the ground that she is not present in court on account of water logging in the area of her residence. Also, prayer none appears for the petitioner, but none appears for. Also, prayer accepted, a registry to list these matters again after 3 weeks on a date to be fixed by it. 55 for 60. Beleg ke maribi. 55 or 60 is over.
Number 3, my name be recorded, Lordship.
And Mr. A. Chalia, learned counsel is present for the respondent number 3. In all the cases?
Yes, sir.
Yeah, please, Lordship. Lordship, in this matter, as per the last order, so this was awaited on respondent number 1 and 2. Whereas, however, the first order says that the respondent at this stage should be served on respondent number 2 and 3 minutes. The 11-5 order.
2 and 3.
2 and 3. Thereafter, minutes somehow it came to be recorded as 1 and 2. We have done our service accordingly on 14/5/2026.
It is there 11-5 to respond number 2 and 3 at this stage.
Yes, Millards. So
Right.
accordingly, we had served Millards. But however, on the next
Where have you served? How have you served?
It was through speed post, Millards.
Speed post, it says that till date no AD card nor unserved notice returned back from so and so in response to the notice issued by speed post on 18/5/26. There is office not here.
Millards, my colleague who is appearing on VC has actually made the speed post, and then actually the tracking receipt he has shared with the
But
court.
it's not there. Here.
He has shared with the court.
It is submitted that
Lordship, we had submitted the process fee, and accordingly, the registry had taken the step with regards to the respondent number 2. With respect to the respondent number 3, we were directed to send it by the speed post. We have also brought the office the tracking report, and it has been we could not hand over because the local council couldn't come due to flood. But it has been sent through the through email to this court, the tracking report. So it says that it has been delivered
the
to
notices were
respondent number
not
2.
sent through the registry.
To respondent number 2, it has been sent to the registry, but for respondent number 3, we were directed by.
Why did you have to send? Why the registry has not sent?
Your Lordship, we were directed that due to some reason for the respondent number 3, it cannot be sent by the registry. So you do the speed post. We did it accordingly.
That is not permissible. And without the effecting of service, we can't proceed in this matter. It is seen
Yes,
that
Your
the
Lordship.
steps in the matter were notices in the matter were issued by speed post upon respondent number 2 and 3 on 18/5/2026. The office note dated 22/7/2026 reveals that neither the AD card nor unserved notice has been returned back. So accordingly, considering the fact that more than 2 months have lapsed since the issuance of notice, since the date the notices were issued to the respondent number 2 and 3, petitioner to take fresh steps for service of notice upon respondent number 2 and 3 by way of speed post. Steps within 2 working days. Please have the registry take it, not you.
Yes, Millards.
Your Lordship, we will do it. Much obliged, sir.
I'm so obliged.
Lordship, can it be put up for a fixed date in on
4 weeks, because it will take 4 weeks. They will immediately place it before me.
Lordship, the humble request is, Lordship, that there is a WA also pending, and it will be heard in next 4 weeks. So, Lordship, if before that we can come before this court.
Sorry.
Much obliged.
Wait, please, Your Lord. At page number 14 of the IA. We just pray for a slight modification of this direction, my lord.
He has not approached till now.
No, because my lord, if he approaches, he has to pay the entire amount in one single installment, my lord. We simply want some flexibility, my lord. Please, if a time period is fixed, my lord, and some installments are.
We have given you within period of 30 days from.
Yes,
today.
but in one single installment, my lord, the amount is
We are
too
not,
huge,
not,
my lord.
not doing it.
25 lakhs, my lord.
You had signed a bond to that.
Yes,
effect.
yes.
Then today we are not doing. We heard Mr. S. Das, learned counsel for the petition. The petitioner, by way of instituting the, and you are seeking basically a review, seeking for a modification of the directions passed by this court-wide order dated 24/3/2026 in WPC number so and so 4059/2018. So, the learned counsel for the petitioner has further submitted that the petitioner has not complied with the said directions. So, on a consideration of the contentions made raised in the contentions made in the interlocutory application, as well as upon hearing the learned counsel for the parties, this court is of the considered view that by way of filing a interlocutory application, a direction which is not found to be erroneous in any manner, which is wherein no error has been found to exist, is not permissible to be so modified. Also, accordingly, the present interlocutory application would not mandate an acceptance. Accordingly, the prayers made in the present interlocutory application would not mandate an acceptance, and the same stands rejected. The interlocutory application stands dismissed. Ms. D. Bora, learned standing counsel, Health and Family Welfare Department, is present. How for liquid level heard as does D. Bora.
Today is, my lord, returnable debt in, my lord, interim prayer lordship. My lord, in the case, my lord, the petitioner was initially suspended in 2022 lordship. Thereafter, in 2024, my lord, he was reinstated lordship. For a long time, my lord, disciplinary proceeding was not initiated lordship. Although initiated, my lord, the inquiry officer expired lordship.
I need
The
some time to
petitioner-
file my affidavit.
Let me submit, my lord. Today is in about consideration interim prayer lordship. My lord, thereafter, my lord, I approached this honorable court. This honorable court directed to my lord initiate the disciplinary proceeding complete within 90 days, and after completion of the proceeding to pass order
When
within
did
30
the
days.
petitioner die?
Sorry, lordship.
Petitioner, you say petitioner expired?
No,
inquiry
inquiry
officer.
officer expired, lordship. My lord, this honorable court directed to my lord pass order within 30 days. Completed. Thereafter, as per order completed, but within 30 days, no, not my lord, passed order, lordship. My lord, I approached this honorable court with contempt petition. That is pending, my lord. In notice has been issued, lordship.
So that
After
will take-
receiving the contempt petition, I have been again suspended, lordship. My lord, saying that the discipline proceeding is pending. Kindly see at page 83, lordship. Page 83, lordship.
Under 6(1)(c).
Lordship. Now, this is, my lord,
This is not a second. They have the power under 6(1)(c).
power, but without what is the reason, my lord? Now, no reason is there, my lord.
I can't presume. They'll have to file an affidavit to that effect.
A short that may be given, lordship.
Lordship, probably service is not completed, lord. It is why the matter has come forward in order.
This is state private respondents. My lord,
Who are the private 6 and 7?
my lord, they are, my
Named
lord,
by,
my lord, issuing authority, lordship.
He says the
Adil Khan
secretary and
lordship.
deputy secretary. Lordship. Sorry, respondent.
Adil Khan, he passed order, lordship.
And Rubojyoti Vaishya?
My lord, he is, my lord, my lord,
So that
he has
service,
also
you have-
hand in this
you
order.
have alleged some malafide against them.
Yes, lordship.
Seen the office note dated 21/7/2026, which reveals that the notices issued upon respondent number 6 and 7 by speed post on 24/7/2026. It submits that the service upon service of notice upon respondent number 6 and 7 is not complete. The notices were highlighted to have been issued on 24/6/2026. The registry to wait for completion of service of notice upon respondent number 6 and 7 for further 2 more weeks. Also, registry to list this matter again after 2 weeks. In the meanwhile, Mr. Upadhyay shall complete his instructions and file an affidavit in the matter.
May I pray for a date, lordship? Obliged.
How to night this date? Hearing it according. Just a moment.
Yes.
1 and 2.
Lordship 1 and 2, Lordship has already heard.
No. Just a minute. There is a list is not complete. There are few matters. Just touch that and come. Mr. Sharma. This is that disciplinary proceeding.
Yes.
But today will not be possible because I have to dictate 4-5 orders. We'll have it on some other day. Any date convenient to you.
My lord. August 17, my lord.
7.
17.
Okay. 17 is 17. As agreed to by the Learned Council for the parties, registry to list this matter again on 17/8/2026. Next. Why is it listed before me?
Because Lordship has heard this matter.
We have
Only
to
judgment
submit a written argument, my lord. Now, it was order will be delivered, my lord. That is why, my lord, it is listed before your lordship. We have submitted our written argument also. Right.
They will not be possible because I have already fixed myself 5-4.
Lordship, I understand.
Registry to, as agreed to by the Learned Council for the parties, registry to list this matter. The khali date diya hai. 25/8/2026. On that day, I'll.
Lordship. Otherwise, my lord, argument is completed.
I got it.
Yeah.
That shop.
Yes, exactly.
Yeah.
Lordship, in this matter today, my only difficulty is, Lordship, I will not be able to assist your Lordship because my brief is missing today.
No need. We don't want. I only want to pass the order.
Yes,
And Mr. Naik, what has happened has happened. We will hold that he is a retired employee from 2016. Poor man, you also has made a default because you had the service book with you. You had the details with you. You have not given him any notice to that effect that you are retiring in 2000.
Pass this.
So and so. So what we do is we will say that he is retired as per 1956 date of birth. This part don't recover, but fix his pay as a pension and all as of 2016. This will treat as re-employment.
Just Lordship will hold that, it's only in, Lordship. But at this stage, Lordship, his date of birth cannot be corrected.
I'll reject that petition. Don't worry about it.
But otherwise, my lord, voter ID, PAN card, Aadhaar
No,
card,
these are all,
everything, my
these
lord.
are, no, these are all subsequent.
Mr. Naik, just have your seat. Mr. Das.
PAN card,
Mr. Das,
Lordship.
there are 2 dates of birth in your. There are 2
Admittedly.
certificates in your school certificates. So when you joined, you might have submitted 1 certificate.
Yes, my lord.
Subsequently, you submitted in 2005 another certificate.
At the time of
Regularization. Both the certificates
Accepted.
submitted by you.
Both these certificates are accepted.
No, both the certificates were submitted by you?
Yes, my lord.
Both the certificates?
No, subsequent certificate, the certificate of the 66 was submitted by me.
By
The
you.
first one was submitted by the office clerk. That is why the censure is there, punishment given.
Okay,
Because original they cannot produce.
okay. Second one was submitted by you in 2005 when
Five.
your regularization process was on.
Yes, my lord.
Was this submitted before the service book was opened or after the service book was?
My lord, that I cannot say.
Now,
Yes,
if
my
you press on that,
No, I
we
am not
will have
pressing.
to determine
Yes, my lord.
whether you are responsible for your extension overstay in service.
No, my lord, I am not.
So in your service book, you have signed 1956, right?
GPF also it is evident.
1956.
56.
So these documents being there, you tried to manipulate. So now we can reject your prayer, clear the 12 lakhs to them.
No, my lord. What is happened, my lord, actually, here is in the numbers of judgment also, I have seen one judgment.
Forget the judgment. Judgments
my
will come later.
But
First the
as
facts.
it is evident, my lord,
Mr. Das, when you signed your service book, when the service book was opened with
Opened,
56,
56.
your this 2005, that certificate of 2005 with 66 was not there.
That was not there.
Then what is the basis for that 56 in your service book, which you have signed?
But yes, thumb impression was there.
Yeah, your signature is there.
No. Thumb impression
Signature.
there. Not signature, my lord. In 66 it is there.
Not 66, in 1956,
No.
2005 service book. Come to page 39. Or you don't know how to sign.
I know, my lord.
Then,
But that is why, my lord,
so this date that is incorporated there, that was done in your presence. You have signed there, Bolenboro.
RTI.
RTI Bolenboro.
Yes, my lord.
So Bolenboro RTI, this is your signature, you have written this. Now tell me, how did this rate, if that certificate, how did this date of birth come into being?
My lord, original certificate, if it is produced, my lord, it can be seen, my lord. Original certificate.
Can I place the original certificate?
Yes, my lord. That is why, my lord. 66 was there, my
I
lord.
can only have the photo.
66 is 2005. Where is the original of 1956? They have produced one here, which is of 2005 again, which is 1956. And
That
on the
is why-
basis of that, you have, but your the certificate is
I-
not there.
I have that, my lord, certificate 66
Hmm.
along with me. Anyway, whatever your lordship already said.
No. If you want to argue, we'll
No,
not
my
argue.
lord. Because
But that may lead to
no,
us to
whenever,
draw
my
a
lord, I go
conclusion.
along with the order, my lord, office will ask for the copy, birth certificate, etc., my lord, PAN card, voter ID. These are
Documents
all-
which
all-
you have created with your own declaration, not with anything else.
One
Yes,
lordship, these are subsequent documents. And
Documents.
second lordship, very recent judgment of the Supreme Court lordship. PAN card, Aadhaar card
Are
is
not-
not sufficient proof for date of birth.
and I card also, my lord.
So we accept the
56.
we accept the inquiry report and say that you were also responsible for your overstay. You had tried to manipulate things.
No, my lord.
We'll say that.
It was accepted. That is why, my lord, Honorable Apex Court, my lord, says that, my lord, if two dates of birth are there, my lord, that has to be, the first one has to be accepted, my lord.
Mr. Das,
Lordship.
don't rub this matter any further. Where it is, let it
Yeah,
be there.
that is good.
But Mr. H. Das, learned counsel for the petitioner in the above note of two with petitions. Also heard Mr. P. Naik, learned additional advocate general appearing for the state respondents, and Mr. R. Boro, learned standing counsel accountant general bracket A&E Assam. That appearing for the respondent number 2. The petitioner, by way of instituting WPC number 1678/2024 has prayed for a direction upon the respondent authorities has assailed a communication dated 39/2020 by which he was directed to appear before an inquiry committee constituted for ascertaining as to whether the petitioner had overstayed in his service. The petitioner has further prayed for a direction for release of his current salaries with effect from the month of August 2020 and for continuance of the same till his actual date of retirement, that is 27/7/2026. The petitioner has also prayed for correction of the date of birth recorded in his service book as apostrophe between 28/12/1956 as 28/7/1966. Subpara could be. In WPC number 6384/2025, correction to cut it. Has prayed for correction to cut it. Has prayed for a direction upon the respondent authorities for correction of his date of birth recorded in his service book as 31/12/1956 apostrophe between as apostrophe pula 28/7/1966. Also, the petitioner herein was initially engaged as a muster roll labor in pursuance to the death of his father, who was at the relevant point of time engaged as a muster roll worker in the establishment of the respondent number 6. Such engagement of the petitioner as a muster roll worker labor was so affected while a communication dated 18/7/1985. The petitioner, being a pre-1493 engagee, his case was covered by the policy decision taken by the government of Assam for regularization of services of master roll, work charge, casual employees engaged prior to 1/4/1993. The case of the petitioner being so processed, on due approval being granted by the government, the services of the petition came to be regularized by an order dated 7/10/2025 with effect from 22/7 to 2025, not 2005, with effect from 22/7/2005. Also, the petitioner thereafter, as a regular employee, was discharging his duties. As the petitioner was discharging his duties as a regular employee in the establishment of the respondent number 6, a communication dated 7/10/2020, a communication dated 39/2020 came to be issued to him, requiring him to appear before a inquiry committee on 7/10/2020 for ascertaining as to whether he had overstayed in his services. Full stop. Thereafter, the inquiry so held having been concluded, comma, the inquiry committee submitted its report in the matter. However, the salaries of the petitioner was withheld with effect from August 2020. The inquiry committee on appreciating the contentions, the statements made by the petitioner before it, as well as from the statements of the departmental authorities and the contemporaneous records, had come to a conclusion that the petitioner was involved in the manipulation of his service records in connivance with one Mohananda Sharma, who was the dealing assistant. Accordingly, the petitioner was held to be guilty, held to be responsible for the overstay in service occasioning in his case, which was held to have caused financial loss, huge financial loss to the government. First, the inquiry committee on a consideration had found that the date of birth of the petitioner in his service book was recorded as 31/12/1956, basing on a school certificate produced by the petitioner. Also, being aggrieved by the conclusions reached by the inquiry committee in its report dated 2010-2020, the petitioner had instituted WPC number 1678/2024. So, during the pendency of the said writ petition, the petitioner had again instituted a writ petition being WPC number 6384/2025, praying for correction of his date of birth as recorded in his service book. So, the correction, the date of birth now required to be recorded in his service book is demonstrated to be 27/7/1966. So, the petitioner in the above background, by projecting that, Mr. H. thus, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the petitioner had submitted a school certificate dated 27/5/2005 before the respondent authorities for the purpose of determination of his date of birth at the time when his services were being considered for regularization. He submits that from the school certificate as produced by him, his date of birth is found to be recorded therein as 28/7/1966. He submits that in the event, he submits that accordingly, the petitioner would retire from his services only with effect from 31/7/2026. However, So, however, the respondent authorities had prevented the petitioner from continuing in his services with effect from August 2016, and the salaries of the petitioner are in arrears with effect from August 2016. Next. Mr. Das submits that the respondent authorities, by projecting that the petitioner, that the date of birth of the petitioner was 31/12/1956, basing on a similar certificate brought on record by some other person, had proceeded to hold that the petitioner had overstayed in his services. He submits that no departmental proceeding came to be instituted against the petitioner in this connection. However, an inquiry being directed, the petitioner had appeared before the constituted inquiry committee. He submits that the inquiry committee, on a superficial examination of the records, as well as the contentions raised by the petitioner, had proceeded to hold that the petitioner was due to retire from his services on 31/12/2016 as per the verification of the records. It was further held that one Mahananda Sharma was prima facie responsible for allowing the petitioner to continue up to July 2020, and for the reason of which a loss to the tune of rupees 12,46,113 had occasion to the government exchequer. The committee recommended institution of appropriate disciplinary action against said Mahananda Sharma and the petitioner herein, as well as for recovery of the amount drawn as salary by the petitioner during the period of his such overstay. So, Mr. Das submits that the respondent authorities, not having further proceeded in the matter and drawn up a departmental proceeding against the petitioner, no recovery would be permissible to be so made from the services, from the pension and pensionary benefits of the petitioner after he had superannuated from his services, after he had retired from his services on reaching the age of superannuation. Mr. Das has further submitted that a proceeding was instituted against, submitted that while an order dated 27/11/20, it is page 55 is 2020. Submits that a penalty of censure was imposed upon Mahananda Sharma for his role in allowing the petitioner to continue in his services beyond his date of superannuation. Mr. Das, thereafter, by referring to the date of birth of the petitioner recorded in his PAN card, Aadhaar card, voters list, etc., has submitted that in all the said documents, the date of birth of the petitioner was recorded as 27/7/1966. He submits that the same being government documents, comma, the date of birth as recorded therein being corresponding to the date of birth recorded in the school certificate produced by the petitioner, that is 27/7/1966. 28/7/1966, comma, the same was mandated to be so considered by the respondent authorities, and a rectification of carried out with regard to the date of birth recorded in the service book of the petitioner as in the date of birth recorded in the service book of the petitioner as 31/12/1956. Accordingly, he prays that the impugned inquiry report be set aside with a further direction to the respondent authorities to effect a correction in the date of birth of the petitioner. The effect a correction in the date of birth recorded, date of birth of the petitioner as recorded in his service book. And also, he also prays that the petitioner be thereafter permitted to continue in his services till July 31/7/2026 by reckoning his date of birth to be 28/7/1966 with all due consequential benefits. Per contra, Mr. P. Nayak at the outset has submitted that in the order issued towards regularization of the services of the petitioner, as well as in the proposal submitted in this connection before the government, the date of birth of the petitioner was recorded as (31/12/1956). The petitioner at no point of time had raised any objections in this connection. Mr. Nayak submits that the said date of birth recorded in against the name of the petitioner in the orders of oblique documents relating to the regularization of his services was so recorded basing on a school certificate furnished by the petitioner. He submits that on the services of the petitioner being regularized, his service book was opened, and therein also the date of birth of the petitioner was recorded as 31/12/1956, and the petitioner in acceptance of the same, as well as the other particulars recorded therein, appended his thumb impression as a thumb impression. Mr. Nayak submits that in the GPF account also, again, that in the GPF account also opened in respect of the petitioner, his date of birth was recorded as 28/12/1956, and the said date was reflected in all the statements that were issued to the petitioner over the period of time. However, he submits that the petitioner had never raised any objections in this connection. Mr. Nayak further, by referring to the inquiry report of the inquiry committee constituted to ascertain as to whether the petitioner had overstayed in his services, had, basing on the materials coming on record during the inquiry, conclusively held that such overstay in service of the petitioner is on account of manipulations made by him in connivance with a head dealing assistants of the establishment wherein the petitioner was serving. He submits that the said conclusions drawn by the inquiry committee would go to reveal that the overstay occasioning in respect of the submits that the overstay in service by the petitioner after the date of his retirement was admittedly on account of reasons attributable to him, and accordingly the salaries drawn by the petitioner during such period of overstay would mandate to be recovered. With regard to the prayer made by the petitioner, next, for correction of his date of birth recorded in his service book, Mr. Naik submits that the said prayer was made only after the petitioner had retired from his services, basing on the date of birth so recorded in the service book. The petitioner, after his regularization of his services, opening of his service book as well as a GPF account, had never approached the authorities praying for rectification of his date of birth. Mr. Naik submits that the petitioner, for the in support of his said prayer, had produced a a certificate dated, a school leaving certificate dated 27/5/2005 with a date of birth recorded therein, with his date of birth recorded therein as 28/7/1966. He submits that the said certificate was not the certificate produced by the petitioner while his case for regularization of his services was being so considered. So accordingly, and further, that the said certificate was not found available in the service records of the petition maintained in the establishment wherein the petitioner was serving. Accordingly, he submits that the said certificate cannot be given any credence. In the above premises, Mr. Naik submits that the petitioner must be deemed to have superannuated from his services on completion of 60 years of age by reckoning his date of birth as 31/12/1956. That is, the petitioner is to be deemed to have retired from his services with effect from 31/12/2016. And he further submits that the salaries drawn by the petitioner with effect from 1/1/2017 till 31/7/2016 would mandate to be recovered from the petitioner. He submits that the salary drawn in excess by the petitioner has already been quantified at rupees 12,46,113. Anything more, Mr. I've heard the learned counsel for the parties and also perused the materials available on record. Also, the petitioner, the services of the petitioner, also, the respondents have projected that the petitioner's case for regularization of his services was processed by reckoning his date of birth to be 31/12/1956. The said the said date of birth was recorded against the name of the petitioner in the order issued by the government towards approving the regularization of services of the petitioner. Thereafter, the petitioner was regularized in his services via an order dated 7/10/2005 with effect from 22/7/2005. In the said order of regularization, full stop. Thereafter, the service book of the petitioner was opened and therein his date of birth was recorded as 31/12/1956, basing on a school leaving certificate dated 27/5/2005 produced, furnished by the petitioner. So, the petitioner now being a regular employee and also entitled to pension and pensionary benefits, a GPF account came to be opened in the name of the petitioner. So, from the statements of the said account, it is found that the date of birth of the petitioner therein was also recorded as 28/12/1956. Also, the petitioner during his long period of service with effect from 2005 till 2016, had never approached the authorities highlighting any error existing in his recorded date of birth in his service book as well as in his GPF account. The respondents on a scrutiny being made with regard to the payment of salaries in the establishment wherein the petitioner was serving, and then it having come to the notice of the respondent authorities that the petitioner was to retire from his services on 31/12/2016, but had overstayed in his services, an inquiry committee was constituted and the petitioner was directed to appear before the said inquiry committee. The inquiry committee, on a consideration of the materials coming on record during the inquiry, as well as on perusal, as well as appreciating the statements made before it by the petitioner, and on appreciating the contemporaneous records, found that in the records maintained with regard to the service of the petitioner, the school certificate wherein his date of birth was recorded as 31/12/1956 was found to be available, while the school certificate wherein his date of birth was recorded as 31/12/1966 was not to be so found available. The inquiry committee had then examine the role of one Mahananda Sharma, a dealing assistant in the establishment, and thereafter proceeded to draw a conclusion that the records were manipulated by the said dealing assistants in connivance with the petitioner, which had led to the petitioner overstaying in his service. The inquiry committee also concluded that the petitioner was due to retire on 31/12/2016 as per the contemporaneous records of his service. Mahananda Sharma was held to be prima facie responsible for permitting the petitioner to continue in his services after 31/12/2016 till July 2020. Also, why they said also, further, the inquiry committee had quantified the amount recoverable from the petitioner on account of his overstay to be rupees 12,46,113. So, the said inquiry as committed, having drawn the said conclusions, the said inquiry committee had recommended for initiation of appropriate disciplinary action both against Mahananda Sharma, said Mahananda Sharma, and the petitioner herein for recovery of the amount of drawn as salary by the petitioner during the period of his overstay. From the materials brought on record, this court does not find that the said recommendation or made by the inquiry committee was acted upon by the respondent authorities in respect of the petitioner herein. So, admittedly, the petitioner may have a role, a hand in he overstaying in his service beyond the date of retirement, but the exact role of the petitioner in the matter was not determined by the respondents by drawing up an appropriate departmental proceeding against him. So, accordingly, the said aspect of the matter remains in the considered view of this court. The role of the petitioner, misrepresentation and or manipulation, the allegation of misrepresentation and or manipulation committed by the petitioner in the matter, in the considered view of this court, remains in the realm of speculation only. Next. The respondents from the date of birth of the petitioner recorded in his service book as well as in his GPF account had the knowledge that the petitioner was slated to superannuate from his services with effect from 31/12/2016. However, it is not found that any notice in this connection came to be issued to the petitioner, intimating him about his date of superannuation from service. The date of birth of the petitioner was also available with the respondent authorities in the form was puso. Accordingly, the respondents also cannot be held to be not blameworthy for the overstay occasioning in respect overstay in service occasioning in respect of the petitioner hearing. Puso. This court notices that the petitioner was earlier a muster roll worker and thereafter was regularized as a grade 4 employee, Khalasi, as a grade 4 employee. And accordingly, he cannot be imputed with the niceties of the service rules and regulations and the date of his superannuation was one aspect which was to be monitored by his superiors in the department. Puso. Accordingly, Puso, having drawn the said conclusions with regard to the overstay in service by the petitioner, this court would now consider the prayer made by the petitioner more specifically in WPC number 6384/2025 for a correction of the date of birth recorded in his service book. The said prayer is found to have been made by the petitioner only only by way of instituting the said writ petition. It is a settled position of law that in the event there is any error in the recording of the in the event an erroneous date of birth has been recorded in the service book of an employee, the same is permissible to be so rectified before a period, before 3 years prior, rectified prior to 3 years from the date of the superannuation of such employee. No such application is found by this court to have been submitted by the petitioner in the matter, in accordance with the procedure in vogue for correction of date of birth. The petitioner has relied upon the date of birth recorded in his PAN card, Aadhaar card, voter ID card, etc. Relied upon so and so in support of his prayer for correction of the date of birth recorded in his service book as recorded in his service book, full stop. The petitioner has now projected that his date of birth is actually 28/7/1966, and for the purpose has also relied upon a school leaving certificate dated 27/5/2005. Also, as noticed herein above, the certificate dated 27/5, school leaving certificate dated 27/5/2005, wherein the date of birth of the petitioner has been recorded as 28/7/1966, is not found in the service records of the petitioner. It is not also the case projected by the petitioner that it was the said certificate that was produced by him at the time when his case for regularization was being so considered. For so, in the event it was the said certificate with the school living certificate with the date of birth therein recorded with the date of birth of the petitioner therein recorded as 28/7/1966, which was produced before the respondent authorities, the petitioner would have objected to the recording of his date of birth in his service book as 31/12/1956. The petitioner is found to have accepted the date of birth recorded in his service book as 31/12/1956 by acknowledging the same to be correct by putting his thumb impression therein. Further, the petitioner was in receipt of the GPF account statements from time to time. And in the said statement also, the date of birth of the petitioner being recorded as 28/12/1956. 28/12. It's recorded as 28/12. 28/12. 28/12, comma. The petitioner had not also raised any grievance in this connection. Be that as it may, the petitioner from his service book as well as the certificate, a school living certificate available in the service records and from the GPF statements of the GPF account is found to have been born in December 1956 and not July 1966. The date of birth as recorded in the PAN card Aadhaar card voter ID card in the considered view of this code being documents subsequent to the joining in service by the petitioner and such date of birth recorded also having an element of a self-declaration being made by the petitioner, would not mandate to be reckoned for the purpose of determining the actual date of birth of the petitioner. Also, in view of the above conclusions, this court having found that the departmental authorities had also contributed towards the overstay in service by the petitioner by not acting upon the materials available on record with regard to the date on which the petitioner was to superannuate from his services, and further, this court not being able to determine that the petitioner had committed a misrepresentation in the matter and or had manipulated records, proceeds to hold that that recovery under such circumstances of the salaries drawn by him during the period of such overstay would be mandated to be recovered. So, para 7, 8, 9, 10. Hmm? 10. No? So, applying the said decisions of the Honorable Supreme Court to the facts of the present case, this court is of the view that the amount of rupees 12,
6113.
12,46,113 from his pension and pensionary benefits to be clearly iniquitous, harsh and arbitrary, and accordingly directs that the said recovery would not be permissible to be made. Also, has your pension and pension benefits finalized? In view of the above discussion, the recovery of the overstay amount or recovery of the salary drawn by the petitioner during his period of overstay having been held by this court to be not permissible, the respondent authorities are now directed to process the process the pension process the pension and pensionary process the matter for preparation of a pension proposal in respect of the petitioner for disbursement to him his pension and pensionary benefits by reckoning that the petitioner had superannuated from his services with effect from 1 to 2016. Also, on such proposal, they said proposal be processed, the matter be processed and the proposal finalized within a period of.
We'll furnish the proposal to the AG
Within how much?
3 months, Lordship.
Within a period of 3 months from the date of receipt of a certified copy of this order. Finalized within period finalized and forwarded to the Office of the Accountant General, Assam, within a period of 3 months from the date of receipt of a certified copy of this order. The Office of the Accountant General, on receipt of such proposal for disbursement of pension and pensionary benefits to the petitioner herein, shall, within a further period of 2 months from the date of receipt of such proposal, issue the requisite pension payment orders / gratuity payment orders to the petitioner. This court having now held that the petitioner stood retired from his services with effect from 31/12/2016 and on account of the pendency of the present proceedings, the pension and pensionary benefits of the petitioner not having been settled, requires the departmental respondent authorities to authorize to the petitioner a provisional pension pending finalization of his pension and pensionary benefits.
Lordship, may I submit, Lordship? As Lordship has fixed the period, Lordship, 3 months plus 2 months. If within this period, Lordship, pension is not finalized, in that situation, provisional pension.
We can't put him in destitute. I wanted to pass this order on that day.
5 months only, Lordship.
Let us know. This is required. This is something which you should have done. They set orders authorizing to the petitioner his provisional pension as well as provisional gratuity be issued within a period of 1 month from the date of receipt of a certified copy of this order. With the above observations and directions, the present petition stands disposed of law.
One thing, Lordship, will clarify. He cannot get pension and salary both, Lordship.
No, he'll only get as this court has permitted the petitioner to retain the salaries drawn by him with effect from 1/1/2017 till 31/7/2006, 1/1/2017, till 31/12/2020, the pension of the petitioner would now be authorized only with effect from 1/8/2020.
Highly evidence.
I sorry you. Thank you that you forgot it. Yep. Mr.
Yes, sir.
Mr. Goswami. I've examined the matter in all formula. The Delhi High Court judgment with regard to that university employees, which has been now upheld by the Supreme Court, will help you. Will help you. Will come in your favor. And the decision of the government, so I've not yet been able to lay my hand on any concrete material, is in a situation wherein the autonomous institutions don't have a pension scheme. In your institution,
Pension scheme is there.
CCS rules along with its amendments or something, whatever the government follows, is being applied.
Accepted them.
Accepted and applied. So in that situation, maybe the employees of Assam University would be covered by 3/3/2023. If it was a case that there is no pension scheme available, then there is no so the problem is the affidavit of the UGC. It does not give a very clear picture. It is neither here nor there. So try to make out a way, but I'm not been able to be very frank. So I'm trying to formulate that issue. That is the ticklish issue there now. Because there is an affidavit before me, wherein they have said that government had taken a decision that this will not apply to autonomous institutions. Now, all autonomous institutions does not have pension. You have pension.
They have accepted.
And in the 2020 notification, which was amended in 2023, clarified further in 2023, 20 was applied to you also, all, irrespective of any bar. This is the place where I am slightly stuck.
Let's say earlier to this, I have held a case for pension, and this court has allowed. But not this. But regarding pension, it has been allowed by this court.
Of Assam University.
Assam University.
What was the issue?
Issue that, let's say, the pension was not given to the employees. They said they are not entitled for pension. Ultimately, this court has allowed the pension.
No, that is because that their own regulations, own resolutions of the committee, governing body said that we have adopted CCS pension rules. And once that is adopted, the consequence follows. Second file to some. Just take up the adoption.
There is a resolution I have enacted.
Just there, I think the click lies. Been thinking of this for the last around 2 days because I know it is coming today. Thinking over it.
Page 212, let's say.
212.
Page 213 is the relevant portion.
Huh?
213 is the relevant portion.
213.
Item number 39, resolution.
University has not prescribed its own norms thereafter. So it's CCA rules which will have monthly. Okay. I've heard the Learned Counsel for the parties. Further hearing concluded, judgment reserved. I think I'll have to apply my mind more.
I will also give the judgment which has been passed by this honorable court regarding the pension of the Assam University. The judgment is
that okay, you can give me. There is one judgment of my Lord Justice Kardagete, not on Assam University, but on autonomous institutions. he has beautifully highlighted that aspect of the matter and said that you are following CCS pension rules, then the consequential things will also have to be given.
But in fact, they have circulated the notification to all employees to submit their proposal.
But one thing, this circulation was just not with the adoption by the GB. It was just a.
Not a casual, let's say. Thereafter, they have said that we have to submit the proposal in the perfect
I know
form.
that this is a administrative decision taken by them. I don't think so. This is a decision taken in pursuance to some GB resolution. It's not that. So this was something they thought that it is normal. It is applicable. But subsequently, it's not the Assam University which is at fault. The UGC's
give it a clarification.
Clarification created the problem. Let us see. I have 2 weeks with me in Arunachal and think of it now. But Mr. Goswami, you give me that. Just you have next to do. Do it to Tini.
Now all these petitioners getting pension.
But you had this CPF scheme. Why the GPF scheme? Why the CPF scheme was there? Because they had adopted the resolution at that
They have in this petitioner they have converted that. That is why you have to challenge.
Converted to CPF. Why?
I do not know. They have done this. All employees are getting pension. All retired employees. Diversion indebtedness. What did you say?
You have this file with you.
Yes.
Huh?
Yes.
UGC had filed an affidavit there. All ko video padi bane to. 7481. 7481 2017. I think the answer is here. It 7481 2007. Thank you. Yeah, thanks. Vijay Kumar Singh. Oh, you have definitely. But Mr. S. Bothaku learn it. Oh, Mr. You have something more?
Status of the deployment proceeding.
কি হয়েছে একো নাই
Okay. Heard Mr. S. Bothaku Learned Counsel for the petition. Also heard Mr. P. Naik. Today it's all P. Naik today. Also heard Mr. P. Naik Learned Additional Advocate General appearing for the respondents. The petitioner in the present proceedings has raised a grievance with regard to non-consideration of his case for promotion from the cadre of Assistant Executive Engineer to the cadre of Executive Engineer in the Public Works Roads
Yes, ma'am.
Roads Department. The petitioner has further prayed for a direction upon the respondent authorities to conclude the departmental proceedings instituted against him while issuance of a show cause notice dated 25/9/2018. Also, the petitioner herein, while working as a assistant executive engineer at Tinsukia, came to be placed under suspension while an order dated 1/7/2017 in pursuance to his arrest in connection with CM. SVC means special,
We came at the same vigilance case, madam.
say CM's vigilance cell. Vigilance Police Station case number 7/2017.
6/17.
7 it's written here. 7/2017. Also, thereafter, a departmental proceeding was instituted against the petitioner while issuance of a show cause notice dated 25/9/2018. The petitioner, being aggrieved by his prolonged suspension, had assailed the order of his suspension dated 1/7/2017 before this court by way of instituting a writ petition being WPC number 220/2018. This court, by an order dated 1/10/2018, had directed for the prospective revocation of the order of suspension of the petitioner and directed for the reinstatement of the petitioner in his service. So the petitioner was accordingly reinstated in his services. The petitioner submitted his show cause reply to the show cause on 30/4/2019, to the show cause notice dated 25/9/2018. So, thereafter, it is seen that the respondent authorities have convened meeting of the Departmental Promotion Committee for considering the cases of the incumbents in the cadre of Assistant Executive Engineer for promotion to the cadre of Executive Engineer. Also, the said departmental promotion committees in the meetings so convened had, however, not considered the case of the petitioner, noticing the departmental as well as criminal proceedings instituted against him. It is further projected by the petitioner that a perusal of the minutes of the selection committee meetings held over the period of time, brought on record in the present writ petition, that the case of the petitioner on consideration on merits was also not kept in the seal cover. It is projected that the petitioner, as of 5/2 2020 petitioner in the gradation list in the seniority list of assistant executive engineer circulated while a notification dated 5/2/2024 was placed at serial number 1. So, it is in the above background that the petitioner has instituted the present writ petition, praying for the reliefs noticed herein above. Mr. S. Bothaku, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the departmental proceedings instituted against the petitioner while the show cause notice dated
25/9/18.
25/9/2018 had not been taken to its logical conclusion. Any inquiry officer appointed? Any inquiry held? No, the inquiry officer is there, but no inquiry.
Inquiry is going on now.
Oh, sir.
This is the last communication made to me.
He submits that the inquiry officer has been appointed in the matter. However, the said inquiry has not concluded and no inquiry report has been submitted by the inquiry officer. Mr. Bothaku submits that on account of the long pendency of the departmental proceeding instituted against the petitioner, the petitioner is being long pendency of the departmental proceeding has caused prejudice to the service interest of the petitioner. He submits that a direction is called upon to be issued by this court upon the respondent authorities requiring the conclusion of the departmental proceedings within a definite time frame. Mr. Bothaku has further submitted that the departmental proceeding and criminal proceeding pending against an employee would be of no consequence for the consideration of his case on merits by the constituted departmental promotion committee for promotion to the next higher grade. However, when he submits that when an employee is under cloud, the recommendation of the selection committee in respect of such employee is required to be kept in a seal cover, which is mandated to be opened only after the conclusion of the proceedings pending against such employee. Mr. Bothaku submits that in the present case, the respondents, although were required to consider the case of the petitioner on merits and keep its Bothaku submits that although the selection committee was required to consider the case of the petitioner on merits and keep its recommendation in a seal cover, the minutes of the meetings of the selection committee reveals that the case of the petitioner was not considered at all. He submits that the respondents have justified the non-consideration of the case of the petitioner by projecting that the petitioner had not submitted his annual property returns as well as his ACRs. The said position is disputed. Mr. Bothaku submits that the said contention is not tenable inasmuch as the ACRs of the APARs, now it's called APARs. ACRs oblique APARs of the petitioner were being forwarded after the same was processed in the matter concerned to the competent authority of the department. APR, what do you say?
The APR we have submitted, madam.
He also submits that the
157.
petitioner had submitted the APRs as per the procedure mandated.
Page 157, madam.
Okay. Accordingly, he submits that there is no reason as to why the case of the petitioner was not considered by the selection committee and its recommendation kept in a seal cover. Mr. Bhattakur, in view of the long delay occasioning in conclusion of the departmental proceeding instituted against him, has prayed that the petitioner be promoted on ad hoc basis as executive engineer pending pending finalization of the departmental proceedings instituted against him. Nothing more, this much will do.
Yes, ma'am.
Per contra, Mr. Naik has submitted that it is a settled position of law which is also envisaged from which is also revealed from the office memorandums issued by the government of Assam in this connection, that an employee against whom a departmental and/or criminal proceeding is so pending is to be considered by the selection committee for promotion on merits, and the decision and the recommendation of the selection committee in respect of such employee is to be kept in a seal cover. From the affidavit filed by the respondents, Mr. Naik further submits that the ACR/APRs of the petitioner, APARs, as well as his annual property returns not being furnished at the appropriate time, a due consideration of the case of the petitioner was not permissible to be so made. He submits.
I'm sorry. So far, his case has been placed before the DPC Lordship on 7 occasions, Lordship, since 2020 to 2025.
But none has considered because of this.
It could not be considered, and the minutes has been annexed in my record.
So there is because of this only.
No, but in last. Sorry, madam.
He submits that the case of the petitioner was placed before the DPC in its meeting held with effect from.
Lordship, the first one on 18/8/2020.
Effect from 2022.
2025.
2025. However, the case of the petitioner was not permissible to be considered on merits in absence of his ACRs/APRs. Mr. Naik has further submitted that the promotions in the Public Works Department is made by also reckoning the gradings given to an officer in the zone of consideration for assessing the merit of such candidate. He submits that in absence of the APRs of the petition, ACRs/APRs of the petitioner, even the procedure prescribed, the merit of the petitioner being not permissible to be determined, no recommendation came to be made in respect of the petitioner by the constituted selection departmental promotion committees. So, accordingly, Mr. Naik submits that the selection committee were prevented from taking recourse to the seal cover procedure in respect of the petitioner only on the ground that the merit of the petitioner was not permissible to be so assessed by it in absence of the ACRs/APRs. Yes.
However, Lordship, at page 168, my last affidavit, Lordship. One post has been kept vacant in the name of the petitioner.
Also, he however submits that the departmental proceeding as well as criminal proceedings instituted against the petitioner not having concluded, comma, so as to ensure that the petitioner is not caused any prejudice on conclusion of such proceedings in his favor, comma, the selection committee has already kept one post of executive engineer reserved for the petitioner. Also, with regard to the prolonged pendency of the departmental proceedings instituted against the petitioner, Mr. Nayak has submitted that the said proceeding admittedly has not, Mr. Nayak, just here, Mr. Nayak has submitted that the departmental proceeding instituted against the petitioner admittedly has not concluded and the same is still pending at the inquiry stage. He submits that this court may pass appropriate orders for an expeditious conclusion of the departmental proceedings instituted against the petitioner, with a further direction requiring the petitioner to also fully cooperate in the matter.
However, fact remains that 2 criminal cases are pending against him.
Only I am talking about the departmental proceeding. Criminal, if there is a charge sheet file, again he'll be under cloud.
Obviously.
There is no charge sheet file.
Yes, charge sheet file.
File.
Trial good.
Also,
Trial
I have heard the learned counsel for the parties and perused the materials available on record. From the submissions of the learned counsel for the petitioner, as well as the contentions raised in the petition, the grievance of the petitioner is that the departmental proceeding instituted against him while issuance of the show cause notice dated 25/9/2018 has not been taken to its logical conclusion till date. The further projection is that on account of the pendency of the said proceeding, departmental proceeding, the petitioner's case for promotion was not taken up by the Departmental Promotion Committee in its meetings held over the period of time after the petitioner was, after a departmental proceeding was instituted against the petitioner. Also, it is an admitted position that the departmental proceedings instituted against the petitioner while the show cause notice dated 25/9/2018 have not been concluded till date. The respondents in the present petition has not brought on record any material to justify the delay occasioning in conclusion of the departmental proceedings instituted against the petitioner. A departmental proceeding instituted against a delinquent is to be so concluded expeditiously and in terms of the, in terms of the Assam discipline manual, Assam disciplinary manual, 6 months.
6 months.
Manual. In the manual of disciplinary proceedings, it is provided that such proceedings have to be so concluded within a period of 6 months. An expeditious conclusion of a departmental proceeding is both in the interest of the delinquent as well as the department, inasmuch as the delay occasioning in conclusion of such proceeding may at a point of time also result in such proceedings being not permissible to be so taken forward in absence of documents as well as witnesses who were originally projected to documents and witnesses for many reasons like superannuation, death, destruction of documents, etc. Also, accordingly, the proceedings instituted against the petitioner by the show cause notice dated 25/9/2018 not having been concluded, this court directs the respondent authorities to conclude the said proceedings when? How much time? 6 months? Within a maximum period, within a maximum period of 6 months from the date of receipt of a certified copy of this order from the petitioner. So, having concluded with regard to the manner in which the disciplinary proceeding instituted against the petitioner would now be taken to its logical conclusion, this court would now consider the grievance raised by the petitioner with regard to his non-promotion to the cadre of executive engineer. The petitioner, being under a cloud on account of departmental as well as criminal proceedings instituted against, the petitioner, he is not entitled to be promoted to the next higher cadre of executive engineer. The policy of the government of Assam in this connection, not having provided for ad hoc promotion, such ad hoc promotion would not be permissible for this court to direct to be effected in respect of the petitioner. The petitioner has contended that the case of the petitioner was not considered by the Departmental Promotion Committee in its meetings held over the period of time after the issuance of the show cause notice dated 25/9/2018 to him, which is projected to have caused a prejudice to him inasmuch as in the event the petitioner is exonerated from the charges framed against him in the departmental as well as the criminal proceedings, he would be left with no reference point to claim his promotion to the cadre of executive engineer. It is a settled position of law. The Honorable Supreme Court in the case of K.V. Janaki Raman, Union of India versus K.V. Janaki Raman, had held that when a charge sheet has been issued, charge sheet / show cause notice has been issued in a departmental proceeding, and a charge sheet has been issued in a criminal proceeding, the employer concerned is to be held to be under a cloud, and his case on considerations on merit by the Departmental Promotion Committee / Selection Committee is to be kept in a sealed cover. Accordingly, in the case of the petitioner, a violation of the said decision of the Honorable Supreme Court is found to have occasioned. The said decision of the Honorable Supreme Court was applied in the state by way of issuance of an office memorandum dated so and so. What did he mean? So and so. The provisions of the said office memorandum is also found to have been. You have that office memorandum? Office memorandum dated
9th May 2006.
9/5/2006. Huh? 9/5/2006. The provisions of the said office memorandum has also been found to have been violated. Also, however, before proceeding further, this court would notice the stand taken by Mr. P. Naik, the submissions made by Mr. P. Naik in this connection. Learned Additional Advocate General appearing for the respondents, in this connection. Mr. Naik has submitted that the selection committee being required, the Department Promotion Committee being required to determine the merit of the candidates before it by reckoning the gradings given to each such candidate in his ACR/APR, the ACR/APR of the petitioner not being available, the selection departmental promotion committee was not in a position to consider the case of the petitioner on merits. Accordingly, the departmental promotion committee had not resorted to the seal cover procedure in his case. It is further projected that the petitioner had also not submitted his annual property returns, which is again a mandated document for the purpose of considering the case of an employee for promotion. Also, the said reasoning given by Mr. P. Naik justifies the non-consideration of the case of the petitioner for promotion to the next higher rank of executive engineer. The petitioner being still under a cloud on account of the institute's pendency of departmental as well as criminal proceedings against him, at this stage, this court refrains from issuing any direction for holding of review the departmental promotion committee meetings for consideration of the case of the petition. Next, however, in the event the petitioner is found to be not blameworthy in the departmental proceeding pending against him, and also in the criminal proceedings instituted against him, wherein charge sheets have been already filed, the respondent authorities shall have the case of the petitioner considered on merits by a review departmental promotion committee for a committee, and basing on such recommendation made, and if the committee recommends for such promotion in respect of the petitioner be promoted to the cadre of executive engineer with retrospective effect, that is with effect from the date his junior in the cadre of assistant executive engineer was so promoted at the first instance. With all aforesaid, the petitioner on his such promotion shall be entitled to notional fixation of his pay, but would be entitled to seniority in the cadre of executive engineer. The said procedure as now directed to be followed by the respondent authorities would redress the grievance of the petitioner of a prejudice being caused to him on account of non-consideration of his case by the selection committee. Anything more is to be added? With the above observations and directions, the present petition stands disposed of.
Once he is acquitted, Lordship, then the.
No, I said not blameworthy.
Yes.
I've used a more good word for it.
It will help him, my lord.
Huh?
It will help him to oppose.
No. If there is, see, if you get acquitted in this,
Obviously.
the charges are dropped in the department proceeding, charge sheet having been filed in the criminal proceeding, you are still under
Yes.
cloud.
Only, my lord, the PR has been submitted on 27/1/25, my lord, before the last DPC, my lord.
That is not required, Lord. In 25, Lordship, we are considering, vacancies of 23 and
25, the
24.
last DPC was held, my lord. Before the 27/1/25.
Oh, they let them do whatever they want to do. By this order, moment you are acquitted,
Obviously.
they'll have to consider your case with that effect.
Obviously.
Monday you will get, not now.
Emergency action.
কি করো? তিনটা আছে। Huh? Really? Mr. Monto, I tried, but I'm not possible.
I understand, my lord. I understand, my lord.
Next week of Khali Kurinas. Last of.
Probably lots of is exhausted, my lord, today.
No, not exhausted, because now no time now, 15
Yes,
minutes
yes.
I cannot.
No, I understand.
5, 6, 7. Due to paucity of time, the said orders could not be delivered. Accordingly, registry to list this matter again on. Kundina Palat me active strike here. Order it.
I'm convenient.
Motion of order to D20. Upload koi button. Arunachal upload koi on 31/7/2026. I'll be in Arunachal thereafter. I'll dictate the order. They will upload it on 3rd from Arunachal.
There is all
for delivery of order.
facility that to be, my lord, obtained.
Now I wanted to finish off these things too.
I realize that.
Good enough.
Lordship fixation.
Which one?
Item number 7, Lordship.
Sorry, 30, Mr. Islam, 30.
37.
37.
Of this month.
I am obliged.
The decision has come. I have got nothing to do. I only have to dictate that covered, gone, SLC, whatever it is there, now the director has to do. That much only I have to say.
Lordship, director has to do, Lordship, at par with my colleague, Lordship, with effect from
Naturally,
1/1/2021.
From the date the 2017 Act was implemented, from that day you will get it.
Lordship, that will do.
From 11 Act.
But my case is from 11 Act because, my lord, I wrongly, my lord, drop out because of the wrong date of
the prayer is 2017.
Lordship, I am obliged.
Because that is a wrongly, my lord, drop.
Mr. Mounta, your prayer is 2017.
Yes, that is true, my lord. But initially, I cannot, my lord, this because at the time,
I can't go beyond.
the post is still vacant. This is the things, my lord.
I am obliged.